accompanied with sufficient level of evidence to justify proof beyond reasonable doubt as required by the Constitution and as determined by this court in advance. And that evidence is beyond the political statements which have been made by my learned friend, Professor Kindiki, just a few minutes ago, and which have never been put on record. On the issue of Rule 87.3, my view and my humble submission is that rule, contrary to the provisions of Section 39 of the Elections Act, and Article 183, 3C, is the only regulatory framework which confers those powers which have been reserved for the Commission and grants them to the chairman. It is contrary to the Act, it is unconstitutional, contrary to the Constitution, and that was so observed in the case of Maina. Now, there was a question raised by Justice Dr. Wanjala, and you queried whether NSC would have gone to influence the alterations of results without knowing the results. My learned friend, who has just appeared, exhorts that the results were known because invitations had been sent out and the letter had been sent out. To the contrary, the evidence before you by the chairman was that he had gone to tally, to obtain the final tally only after he had met the commission, and that is found at paragraph 676 of his affidavit, where he says that after the NSAC team had left, the commission secretary, chief executive officer, who was also the alternate team leader of the tallying center, Marjan Hussain, walked into the boardroom. Yeah. The purpose of the meeting was to receive the final tally of the results of the presidential elections before he could proceed to declare. And it is only thereafter that the results were handed to the commissioners and they walked out. So that even by the admission of the chairman, he was not aware of the results until after the NSAC team had left. Now, the Deputy Chief Justice asked about the effect of NSAC on the independence of IEBC. Your Ladyship, NSAC is a body comprised of all the heads of the security organs in this country, the head of civil service, the representative of Attorney General, and other heads in the government. Its purpose is to receive all the information on national security and give advice, not act, but give advice, so that even if they are of the view that it is insecure to be in this court at this time, it is the NSC who will give advice to the judiciary, and that is not an interference with the independence. And we have to take their role in the context that these four members of the NSAC were co-opted by the bigger body. They were not there on their own account, which has led to them now being vilified for undertaking an official duty they were requested to undertake. I had shouts from another friend on behalf of His Excellency, the Deputy President, of crucify them. In fact, this has indeed led to tweets today, and there are many, to various members of the NSAC telling them we shall revisit. This is what this type of allegation brings, and that is why I humbly request this court to look at the nature of the allegation, the burden on the people who are making the allegation, and dismiss them if there is no proof, and in my humble submission there is no proof, so that we discourage this political vilification on officers conducting their official duties. Let's be careful, and I humbly request particularly my learned colleagues on what we wish for this country. Let us not wish mob justice to be the arena of operations whenever various functionaries are discharging their duties. Let politicians do politics, but let them leave professionalism to those who are engaged in various areas. In fact, since this process started, there has been a lot of vilification on the judges, on the parties appearing. In fact, tweeting has been the norm on discussing this issue instead of looking at it soberly. We can't stop tweeting, they are entitled to, but we can't bring it to this court. That's my humble submission. I beg that these allegations be dismissed with the contempt they deserve. My learned friend, Mr. Gatia, requests for donation of the 2 minutes to him, but I really would wish not to be so gratuitous.
Thank you. Madam Chief Justice, if you may allow me, I did not put one of our lawyers on record, Mr. Donald Kipkorir, who is not in court because of the sitting arrangements. But to come to the business before us, in answer to the questions, 4 of us will deal with all the questions that were asked by the court, beginning with my learned friend, Mr. Paul Mwangi.
Madam Chief Justice, Madam Lady Deputy Chief Justice, my lords, my ladies, I have 9 questions which I'll tackle very first. What I have done is I have classified it into topics because they were across the board. The first is the relevance of rejected votes in the counts of the election. This is a matter that we have asked the court both in 2013 and 2017 to relook. We wish to resubmit as we resubmitted the 2 times, and to say that it is still our position that people who come out to vote, whether their vote is counted or not, are coming out to make a stand on the issue, and whether either due to technicality or other reason their vote is not counted, they must be not treated as those who stayed at home. They are people who came to express an opinion on how they want to be led, but for various reasons their vote was not counted. But the fact that they appeared should be taken into account, so that you would consider their votes whether they are rejected, and even if they are called stray ballots, should also be considered in that sum. The second question was regarding the scientific whether there are any scientific studies regarding the nexus of elections in a postponement. We have seen, unfortunately, we could not tender any further documents of this, but there are very many theories in political science, one of which we came across with the contagion theory, that elections affect each other. People come out to vote for various reasons, and especially when you're dealing with elections of a national level and a devolved level, there are very many considerations that would make somebody want to come to make a decision on a devolved government or a national government and not necessarily care about the other. But one of the things that we also must consider in Kenya's political culture is that in Kenya we do have six-piece kind of campaigns, and that people come out to campaign together as teams, trying to win across the board on all the seats. And that when you disenfranchise one, when you stop one election, that means you demobilize part of the political infrastructure that is laid out for that. And lastly, on this point, we want the court also to consider that, at least in respect of Mombasa, and our evidence has shown that there was an order from the Mombasa High Court that has stopped the printing of these ballots, and that was disobeyed. There was also a promise that had been made by the chairman that he will not print, and he went against that too. And lastly, that it was announced on the last minute in that night. The third issue was what elements of Section 80 of the Elections Act we consider necessary in the face of the fact that we are also impeached the process. Apart from the elements that are laid out themselves in Section 80, which is that upon a recount, the person should have been a winner, and that the person should be found not to have committed any electoral offense. In our submission, we wish to add that first, the test should be whether the petitioner is culpable for any of the wrongdoings that is complained of. Secondly, whether the petitioner benefited from any of the wrongdoings that are complained of. And thirdly, that after, whether it is a recount or a retally, the petitioner appears to have won the elections or has won the election. Those would be the tests that we would add to what is stated in Section 80. In respect of the question of image on the KIMS, the evidence that has been shown also even from the Commission is that the images are taken on a JPEG format, and the idea of the law of electronic transmission was that that image must appear as it is on the other end. The issue here is that there appears to be a place at which that format was changed. No reason has been given why that format was changed, so that it can go to any other format. But also to add that through one of the most popular applications today in Kenya is WhatsApp, and nobody changes. We get a lot of images as original as they are, as colored as they are, in the hundreds on an everyday basis. And I do not think there is any justification why an image taken on a JPEG on a KIMS kit cannot appear in the same format throughout the electoral process. The other question was in respect of the evidence, whether the 4 commissioners participated and what that meant. I would ask the court to look at the annexures that are put as MWK3 in the affidavit of the second petitioner, Martha Karua. And in that flash disk, there are 2 incidences at the National Tallying Center. In one incident, Commissioner Justice Nyang'aya comes out to read the results of Kiambu Town constituency. After he reads the results, it turns out that the result he has read has overstated the votes of William Ruto by 10,000, and also that he has gone past 100% of the votes cast, and he is forced to have to come to reread the results. That shows the commissioner had not known what he was reading. The other video is that also of Juniera Cherele. Again, she's given results to read of Juja constituency with the same results, inflated votes for the respondent, and a more than 100% voter turnout. And again, the results have to be reread. That would leave it to the commissioners themselves to explain. The other issue is about the constitutionality of Regulation 87. Now, first, our position is that a regulation or any act that is unconstitutional does not need the order of the court to be nullified. It is already nullified by Article 2. And at any time, it remains a nullity ab initio. The second issue to consider is the duty of every person, not just the court, to defend the Constitution as required by Article 3. And the fact that this chairman, the chairman of the Iebc, is a person who has qualifications similar to be the Supreme Court judge. So it is who has betrayed the Constitution. It is him who has seen a regulation which is so clearly unconstitutional, has refused to defend the Constitution, and instead feigned ignorance and purported to use an unconstitutional provision to exercise power. So on that basis, every action that is done on the basis of that regulation is itself unconstitutional. The other question was regarding why the 4 commissioners did not raise issues to the end. Again, that we will leave for the commissioners to decide, but we can profile 3 theories. One is the issue of the 89th minute penalty, that if you participate in a game and a wrong penalty is given on the 89th minute, you cannot be asked, why did you play all along? Sometimes it is the 89th minute penalty that shows the unfairness of the provision. It could be the last straw that broke the camel's back, or it could be a road to Damascus moment. In whichever fashion we look at it, it is an issue that is understandable. The other question is in regarding for if there were to be ordered an repeat election, who would conduct it? Would go back to Article 250, Sub-Article 10, because the Constitution provides for positions of vice chairpersons of all commissions. But Article 250 does not lay out any roles that they're supposed to be undertaken by those vice chairpersons. Our position is that that provision is not empty, and it is meant to provide for succession plans in commissions in places where an emergency or situations such as this, where such a succession is necessary. But the second issue would also be that the court itself, its inherent powers, has the power to ensure that its orders are fully obeyed and fully executed. And in such a situation, the court would treat its order as an order that has to be executed and would have the inherent powers to make all such other orders that are necessary to ensure that those orders are executed in full. Before I go to my last issue, I want to comment on something that was said about no agents. And one of the issues this court was told is that it appears there is a jurisprudence that is being built, that where an agent does not appear from the other side, then the opposing side has a right to steal or a right to commit fraud, or somehow excuses the Iebc from any duties because there was no agent. And in fact, one of the advocates, like Kent, said that you must have agents in every place, and even likened to, I said they should be like your wife. I believe that is what was said. Apart from the fact that that statement is very sexist and insulting, not just to women, but even to constitutionalism, their course must restate the duty of Iebc to protect the vote at all times in every place, and that it cannot pass the buck to parties when wrongs happen, and also must put the obligation on every contestant in an election that if you meet a place where there is no agent, it does not give you a right to steal the election in that place. The last issue, and I follow this up with what my learned friend Mahat did, I want to show the codes as Form 34A from a place called Gasharaigo Primary School. And it is in Murang'a, in Kangema constituency, in a ward called Murugo, in stream 2 of 2. And this document is overlaid over some documents, but look at the left-hand top corner. It is overlaid over a document written Jose, this is Jose Camargo. Jose Camargo is one of the Venezuelans that was arrested at the airport with charges of coming to interfere with the elections. He is one of the people that the last Mahat has said did not have access to the RTS. This form is in the official portal of Iebc. The question would be, was this document photographed by a presiding officer at Gasharaigo Primary School, sometimes possibly at 8 o'clock in the night? Or is it possible that this document has been photographed elsewhere in some office and uploaded? This, we ask the court to read the DCI report regarding Jose Camargo, and we believe, my lords, that these are the fingerprints of one of the suspects of the theft of this election. That is all.
Good morning, my ladies and my lords. I will pick up from where my learned colleague and senior Mr. Paul Mwangi has just left off. The court had asked that we demonstrate with examples in real time how the Form 34A was interfered with or could be interfered with. And I will do so showing you or using the IEBC's forms itself, straight from the from the IEBC portal. My lords and my ladies, I will walk you back through the form that we have just showed you. I see that the court has laptops, which means you're tech savvy and you can access the IEBC portal right now. This is going to be a live demonstration as the court asked that we do. I'm asking that we go to the forms portal in the IEBC. We are projecting it up so that it's not said, because we have been accused of cooking things, forging things. We've been called many names. This is the IEBC's own document. We're asking that you open on your own devices, but even as we show, Murang'a County. Kangema, Muguru, and Gasharaigo Primary School 02. This is live. My lords and my ladies, we have downloaded a Form 34A from the IEBC portal. And I'd like the court to just scrutinize this form before we go to other details. From where I am, the stamp. The stamp. My lords and my ladies, is that the IEBC stamp? It's on the IEBC portal, looking like it's been superimposed over another stamp. We have been asked to show how are the figures changed. The votes. Now, my lords and my ladies, if we look at the votes cast, the first figure on the form is for Raila Odinga, 55. It's followed by William Ruto, 260. It's followed by, I think that's Mwaure Waiga, 001. And the last is Wajakoya, 000. If we sum up the total votes, we get 316. The total votes cast according to this particular form is 321, different from what we have just seen. The rejected votes are 4, which means already by calculation there is a problem. But we'd like the court to look at the total number of registered voters. A close scrutiny of the form shows that the number was probably 455, and the 5 is actually similar to the figures written in the votes cast. But somebody or somehow that figure has been changed to make it look like 488. It is obvious to the naked eye when you look at that form. Now, when we go to now the bombshell itself, the top left-hand corner of the form, we were told by my colleague, Mr. Gumbo, there were no foreigners in this election. We were told the foreigners left before the 8th of August. We were told they did not even have access to maintain the server. This is on the 9th of August, and at the top left-hand corner there is the name of one of the Venezuelans, Jose Camargo. This is the person who decided the president-elect of the country. It is on the IEBC portal. It is live. How did that come there? What are you doing? This person is the one who was interfering with the forms. We are able to demonstrate at least a crumb was left. By God's grace, we found something. We didn't make this up. We were told we forged these documents. Now, this is how, my lords, the staging was happening. This is how the changes were happening. This is on the 9th of August. We were told they were not there. I'm going to do, because of time,
with your permission, Your Ladyship.
I beg your pardon. In our petition,
you let her finish and then you tell us what it is. they're responding.
It relates to an objection to what she's doing, Your Ladyship.
No, let her finish.
And it's not the IEC.
My ladies, my lords, that name, Jose Camargo Gregorio, appears in our petition and is also, that evidence is also found in the affidavit of the second petitioner, one of the people whom we complained about as having interfered in the election and who were told had no access. My lady, we're going to take you again on the same IBC live portal to show how the staging was happened. And because of time, if we can go to Bungoma. We want to do it live, and we're doing it live on the IBC portal. My lady, we were told about the KIMS kit and how they work. The serialization of the numbers. We have been told that each of the 42,201 KIMS kits that were used in the election had their own unique KIMS kit ID and serial numbers. Bungoma County, Mount Elgon, Chesikaki, and Songoyo. We'll download the form. The nomenclature of the KIMS kit and the form is shown at the top on the address bar. And for purposes of time, my lady, what we're told, it will show you that that's a Form 34A. It will give you the serial code of the polling station from which that Form 34A relates, and then it will show you the KIMS kit serial number or ID. There'll be a date stamp and a time stamp. What I'd like the court to focus on is the serial number, and perhaps because I can't see from here, this is where I would have liked the court to have its own, but maybe if it can be. Do you have a roving mic? Now, the serial number on this particular form, my ladies and my lords, which I would have liked for the court to confirm for itself. If somebody there can, may I ask one of the court assistants to read for us the serial number as it is, so that then I'm not accused of making up things.
That's all right. It doesn't change anything. Evelyn, could you read that?
The number that starts with F2, it's in the middle. Or can I read it myself?
I can't see it. The one on top.
Yes.
TR06.
No. The one.
Oh, sorry. F2.
My ladies and my lords, what would require is that you note down that number. We will compare it with another later.
It reads F230 450M00204-133.
The time, please. It's right next on the date.
That one. The time is
The date on which
9th August 2022 at 1956.
We'll check another form. Nyeri? Nyeri Town? Gatitu? Morogoro? Thunguma Primary School? Stream 3. Kindly read the serial number.
F230450M00204133.
And the date and time, please.
9th August 2022 at 23:49.
My ladies and my lords, this is the same KIMS kit transmitting or sending results, one from Mount Elgon, 1,000 kilometers away from Nyeri Town. 2 hours later, how is that possible? When each KIMS kit was supposed to have, each polling station had its own unique KIMS kit, which was supposed to transmit from its own unique IP address. Because of time, I cannot demonstrate the thousands of forms that we have identified with the same issue. My ladies and my lords, this is how the staging or the complaint that we raised happened. We did not give this court a fiction. What we gave the court happened. Now, staging, and as we have shown, the 11,000 polling stations that we had complained were staged were transmitted all from one IP address. Every KIMS kit was required to have its own unique IP address. The only way 11,000 KIMS kits or results can be transmitted from one IP address is if they were collected, and as probably my senior Paul Mwangi had. May I beg your pardon, my time is up.
Yes, 2 minutes.
Yes. My ladies and my lords, the manner in which the election was stolen, the reason why staging was necessary was forms were intercepted like this. Whoever intercepted them then had time to decide which ones they could manipulate before uploading them and sending them to the IBC portal. The other reason that we know there was manipulation is because the original Form 34A is a colored form that should have appeared at the National Tallying Center if transmitted in one transaction as a colored form. All the forms that are on the IBC portal are in black and white. At what point were they altered from JPEG to PDF? When did that modification happen? And what other modification was done to the form? We submit to you that we have shown that not only was it possible, it did happen, and the fingerprints of those who interfered in the systems are still there. Thank you for your time. I don't know whether to be that generous. I donate the 29 seconds to the court. Thank you very much. At the insistence of my seniors.
May it please the court, my name is Kirago Kimani. My learned friend, Mr. Katua Kigen, had gotten the attention of the court, but was asked to wait until Ms. Soweto had completed her presentation. I would wish to respond to what she has just addressed you on, because this is new material, and would like to have directions.
Mr. Kirago?
Yes.
When I forget his name, Mahat was answering the questions, he did the same.
Yes.
He went through his PowerPoint.
That's correct.
To demonstrate.
That's correct.
How this staging was happening, because we asked that we be explained.
Yes.
How the forms were being captured in the hair. Yes. And being changed. And he did that.
Yes.
Going back to what he had done.
Yes.
So what is new here?
What is different is this. You have a petitioner and you have rules that say how they are to present their case.
This was answering a question from court.
Yes. Where does the first respondent have an opportunity to address these matters? At what point in time does the first respondent get a hearing?
This was a question by the court to demonstrate.
Yes.
How this was happening.
Yes.
How we do, what we do with the demonstration. Mr. Mahat on your side did demonstrate.
Mr.
And they have demonstrated.
I appreciate what your ladyship is saying, but Mr. Mahat, with respect, is not on our side. He is a referee. My client was a candidate. We are not on the same side. We may be respondents, but he called this match, not for us, but is required by the Constitution.
Mr.
But anyway,
Kirago,
the long and short of it is, yes.
I'm
the long
sorry.
and short, yes.
We are not going to give you time.
Much obliged.
Yes, thank you. Proceed with, there were responses from the other petitioners. I'm beginning with number one, the same order we followed.
Remove that one.
You have responded. So who was next? It was, I think, Senior Counsel Jan Mohammed was her client. The same order we followed so that we don't waste time. If you can't use the 15 minutes, please.
Your Ladyship, Madam Chief Justice. Your Ladyship, Madam Deputy Chief Justice. My lady and my lords, I was very generous in my opening, so I'm sure I'm going to be just as generous and patriotic as I am in my rejoinder. I had donated, I was the first one to donate 7 minutes in my opening.
Okay.
My lady, on behalf of the petitioner, in number one, that's the second petitioner, we had filed a rejoinder of the submissions after our original submissions. And my lady, the petitioner's case is very simple. All it was the petition was limited to a legal issue. It was the role of the commissioners vis-a-vis the chairperson.
I saw people murmuring, and I want to get this correct.
I'm sorry.
Is it that we should Then, because I thought you had a response, you had any question to answer?
In fact, my lady, the question I'm going to be answering is actually the rejoinder as to the role, as the answer to the role.
For purposes of orderliness, because we are trying to get our proceedings as orderly as possible, then we can start with the rejoinder by the first petitioner, then the others will answer the questions with their rejoinder.
Because my actually rejoinder is the response to the question of what the role of the other commissioners was vis-a-vis the chairman and the commission. Okay. That's what my entire petition is based on.
So then we start with the main petition,
that's fine.
Rejoinder, then we come to you. I'm sorry about that.
That's no problem, my lady. I'll still donate my time.
Yes. Senior Counsel Orengo, it's your turn.
I'm just wondering, because if I heard the court correctly, there are some questions put to Mr. Mtata.
They will respond with their rejoinder.
With the rejoinder?
Yes.
Oh, okay, then that's correct. In our rejoinder, Madam Chief Justice and the members of the court will have 4 in our team giving the rejoinder. Senior Counsel Firoz Norji, Senior Counsel Otiende Amolo, and Senior Counsel Philip Morgor, and I'll have 5 minutes at the end. Okay. But I'll begin with Senior Counsel Otiende Amolo.
If it may please Your Ladyship, this Honorable Court, I will be brief in this part. I will cover only 3 quick subjects, starting with the issue of the 50% plus 1. Your Ladyship, this Honorable Court, may it be noted that the question of the voter turnout in this election is a moving target. It is a moving target depending on who's speaking and in what circumstances. If you look at the replying affidavit of the chairman, paragraph 30, as of 9th of August at 5 p.m., he says the turnout was 64.6%. That is an affidavit he's swearing way after the fact. The Director of Elections of that same date, at that same time, in paragraph 21, that is Moses Sunkuli, says it was 56.17 at that same time, looking at the same Kimskit. It will be noted by this Honorable Court that at various times, the Iebc gives different figures. At one time, it uses the figure of 65.4%. At another time, it uses the figure of 64.6%. It is our submission, my lords, my lady, that the premise upon which Iebc proceeds is wrong, and that the reason for this moving target is so as to manipulate the question voter turnout, to come to a conclusion that the 9th respondent met the constitutional threshold when they didn't. I wish to submit, Your Ladyship, my lords, that Article 138 is very clear, and the total number of registered voters must be specified, and that is the denominator. The Iebc did publish a Gazette notice that confirms the exact number of registered voters and gives it as 22,120,458. In this court, using what they say is the turnout per the Kimskit, the figure they are seeking to use is 22,005,541. We wish to submit, Your Ladyship, my lords, that that premise is problematic. The common denominator to be used is the voter turnout as published in the Gazette, not the voter turnout as per the Kimskit, which ends up with a moving target. We wish to submit, Your Ladyship, my lords, that not only is it true that the target is moving, if you look at all the permutations, and this is in the supplementary affidavit of Dr. Edgar Otumba, if you take any of the scenarios and you use any of them, and we will submit, we have submitted this for ease of reference, because Dr. Oktumba covers this between paragraph 5 and paragraph 30, and puts all those graphs. By whichever permutation, none of the candidates then achieves 50% plus 1. Whether you use, remove rejected votes, you add rejected votes, whatever permutation, and there are 7. We wish to submit, Your Ladyship, my lords, that you then need to come to the conclusion that even though they try to take time to tamper with the voter turnout, they do not achieve that target. The last point on that. Why is it wrong to use the vote turnout as per the so-called Kim's kit? Other than the fact that it's unlawful, it is also illogical. We have 46,229 polling stations. If you are to rely on the Kim's kit, and all 42,298 Kim's kits failed, and only one polling station functioned, then it means that if the 700 voters in that polling station voted, the Iebc will be telling us that the voter turnout is 100%. That would be the logical consequence of that narration. The voter turnout cannot be something that depends on the interpretation of the Iebc at its convenience. It must be the denominator as a percentage of the total registered voters. My second point, my lords, my lady, and I do not want to go too much into this, the question of the infrastructure, what the Iebc called the impregnable military style infrastructure. I think it's been demonstrated that it was certainly not at a military grade. It might be important to note, Your Ladyship, my lady, that the one question they failed to answer was why was there stoppage of the streaming of the results at Bomas? They have not answered that, because that military grade infrastructure was obviously compromised. My lord, my lady, we say that it is bad to have a sovereign institution that is captured by the state, but it is worse to have one that is captured by foreigners. We submit that is the position in this one. Your Ladyship, my lord, the question here, and that's my third and last point, is really very simple. And it's a question that draws directly from Article 138(3)(c) of the Constitution. It is very clear, it is mandatory, that once results are received, the Iebc, not the chair, shall tally and shall verify, then shall declare results. If the Iebc as an institution has not tallied, has not verified, then there are no results to be declared. We wish to submit that at the end of this analysis, it is not a question of whether the chair is a hero or otherwise. It is a question of whether the chair did what was expected of them. It is not enough to say that there are certain regulations by the first respondent which they themselves made and now they wish to rely on to breach the express provisions of the Constitution. We wish to submit, Your Ladyship, that in accordance with Article 141, only if there's a result properly declared can you even move to challenge it. In this case, none was done. Your Ladyship, what the chair is inviting you to do is unconstitutional. This bench comprises eminent persons who are involved in the process of making the Constitution, as some of us on this other side. There's a good reason why we've created constitutional commissions and independent offices. If it was intended to create the chair as what was previously called the supervisor of election, there'd have been an independent office, like the Auditor General, Controller of Budget, like the DPP. But now the chair is inviting you to find that his is some sort of imperial chairmanship or chairpersonship in defiance of the Constitution. We wish to invite you not to accept that invitation to amend the Constitution belatedly. my lady, my lords, at the end of the day, the only question will be, did the chair act in accordance with the Constitution? Is it fair to invite you to find that the other commissioners do not matter? The chair of IEBC is a first among equals, just like in this court. There are 7, just like the judges of this court. But the fact, your ladyship, you are the Chief Justice and you are the President of this court. Yet the Constitution would not allow you to exercise veto powers over the other colleagues. Why would the chair believe that he can have such powers over the other colleagues? Ultimately, my lords, your lady, it is the decision of the majority that must be the decision of the court. And similarly to the IEBC, as we are here today, the decision of the IEBC is that the match that was being played was stopped by the referee. If it was in court, it would be a mistrial. By their own admission, they have said that things happened which should not have happened, and therefore it was not complete. My lords, my lady, in 2017, this court made history by nullifying the first presidential election in this continent, and I think only the second known to me in the world. In this year, it is the IEBC that is making history. It is the first electoral body to concede that they did wrong. I want to submit, my ladies, my lords, that you cannot override that decision by IEBC itself because it's made by the majority. I wish to stop there for now. Thank you, my lord.
My Lady Chief Justice, members of the court, I address the court firstly on the issue that in making your final decisions, in reviewing your own views, the views of the respondents, petitioners, parties who have addressed you, we would be praying for the prayers and orders that we have sought. And in doing this, may I first refer to the principle that would be applicable in approaching your decision and judgment. In this context, the court has heard today from my senior, AG Emeritus, Honorable Gitu Muigai, in answer to your question, that it was the intention of the makers, it was the intention of the makers that the commission should have an executive chairperson. That we have learnt much by that, but that is not what we or they and your ladyships and lordships can proceed on. We have to proceed on what is in the Constitution. There is no provision in the Constitution for the, even if that were the intention, there is no intention shown to override any of the other commissioners or their views or their actions or to change the Constitution's clear provisions of Article 138(3)(c). The tallying has to be done by the Iebc. The verification has to be done by the Iebc. The declaration decision has to be made by the Iebc. And where there is a specific step to be taken in an executive fashion by the chairman, it's provided by 138(10). The declaration of the decision of the result will be made by the chairperson. Secondly, it is an important consideration. When yesterday the question arose of the two aspects. One, that although there was a further day still in hand, the chairperson rushed to judgment without the 27 constituency results because of the doctrine of necessity, said Counsel Professor Kindiki, in justification of this. The doctrine of necessity was not necessary at all. There was no crisis at that moment. They were, he has indicated, in great danger of their lives. But 20 minutes later, they were shaking hands with his client, and his client was shaking hands with a very able-bodied chairperson. Nobody left that hall in the imminent expectation of watching carnage and bodies lying all over the floor. No one. There were church people, 2 rows of church people. There were, and I am grateful to them, the choirs who had kept us not entertained only, but inspired through those hours and hours. There was no imminent danger. This continuous, they could not resist the temptation of showing a still photograph in order to show that there was a necessity. No, there was not. And it is very important to realize that we do not use these exaggerated criteria in order to come to a justification of plain wrong. Is it, the issue is, was the Constitution being followed or not? And that is where the concentration has been lacking from the respondents. An important aspect of this, of bringing forward the doctrine of necessity, is that it is a very dangerous legal justification. It shows the need to bypass the constitutional justifications and arrive at a subjective, convenient, and self-serving justification. And it is dangerous because it has been used before by lawyers as eminent as Professor Kindiki. It has been used in Rhodesia after the UDI, unilateral Declaration of Independence to hang freedom fighters who were resisting the Universal Declaration of Independence. And the doctrine of necessity goes one step forward to say that if power has been usurped, taken, otherwise than in compliance with the Constitution, the courts should still I think, by Professor Kindiki and placed before the people of Kenya, we say not only rejected, but rejected consciously, so that the precedent is not of a submission which failed, but a precedent of the Supreme Court of our land rejecting this ever for use in Kenya. So what should we be using? I'm happy to say that again from the respondent's side, I draw some inspiration. And that is from my learned friend, Senior Counsel Fred Gatia. My learned friend, both learned and friend, put forward before the court and he said, let us get at the substantive truths. He put forward a criteria completely different from Professor Kindiki. And I'm happy to say, yes, let's do that. So we put to you, when we put forward the manipulated postponement of Mombasa and Kakamega, we showed to the court that the Gazette notice, the power which Mr. Chebukati used, was illegal because in the Gazette notice he lied and put forward just half of what the power he has needs to meet. And so when we put these forward, they could not reply, but those who attempted the reply said, but look at this is his power, this is his section here, and he's an executive, he's this. But Senior Counsel Gatia's principle was a more important and relevant approach. So we say, what is the substantive truth behind the postponement, behind the lying Gazette notice, before the self-serving amendment of the Regulation 67 by which he changed, this chairperson changed, or got changed, the constitutional provision that the papers 34A and B received at Bomas must be dealt with by the Iebc Commission. Instead, he changed it to the returning officer. It has been pointed out there is no such office, and he put it there. What is the substantive truth behind this? What is the substantive truth behind the fact that despite several orders from you, the server has not been fully opened? What is the substantive truth behind the fact that this is not the first time this chairperson has disobeyed the court? What is the substantive truth of the absence from his behavior of any reference to Article 10? Article 10 is values. They are national values. And the beauty of our Constitution is that it is not only a manual of government, finance will be dealt with this way, so-and-so will be appointed that way, he can resign or he has to be removed or this or that. Each and every chapter has its specific values set out therein. 81, 86, and at no point in the whole of the day spent and today, this morning, has there been any reference by the respondents' counsel or supporters, or by any reference to instructions, that these values we kept in mind? This is how we advance. By postponing Kakamega, this is the value we advanced. By not checking the wrong printing of the ballot paper, how did we advance Article 10? There is even one more duty on them, on the chairperson. It is that it is part of the duty of the chairperson, the whole commission, to ensure the removal of any impediments to the functioning and the purpose and the aims of the commission. They have breached even that, even the passive duty. And we say, yes, that is what we look at, the substantive truth of all these things. And in that, once you do this, it is clear that this is an election which is brazenly, shamefacedly, without remorse, saying we did right when we were doing wrong. You do what you can about it. Nothing happened to me in 2017 personally. And it is all right. We say no, and we say to the court that not only is the petition, we pray, to succeed, but very importantly, if you find that there is violation of the Constitution by the chairperson, it is not necessary for the court to take any steps to his removal. There is a constitutional position. Thank you. There is a constitutional process to remove him, and there is no need for the court. But there is an important duty on the court that if you find a serious violation, and we submit there are all these serious violations, it is important that the court makes a finding. We hold that, or we find that the chairperson violated this article or that value, and that those are set out. We pray accordingly. Thank you.
Having just come in, good morning, your ladyships and my lords. I'll take as short as possible. In order not to repeat, I will be very brief. Arising from the questions asked by the court, I'd just like to put it on record that and of course, in particular, the very rapid submissions of my learned colleague, Mr. Mahat. Sometimes you miss exactly what he's saying, but I picked out that he did not at all mention how the system for the KIMS kit was converted to the provision of PDF. The tender document, and we have provided evidence of it, did provide that the KIMS kit would transmit a compressed color photograph image using a compression technique that is in compliance with JPEG. That requirement was never changed unless it was changed quietly, fraudulently, and with the sole intention of rigging the just concluded presidential election. My learned friend again, Mr. Mahat, challenged everybody that if there was a program that could convert a PDF document or could edit a PDF document, they would buy it. They would buy it. I suppose he meant the Iebc. I, at that point, did ask whether he's an employee of the Iebc, but I was assured he was not. I would like to state for the record that the software for editing a PDF document is available free of charge and can be downloaded by him or the Iebc. And we would request that millions of public money not be used to do this. But the programs that exist for editing a PDF document include Adobe Acrobat DC, Foxit PDF Editor, PDF Filler by AirSlate, PDF Element, Small PDF, Nitro PDF Productivity, Fine Reader PDF for Windows and Mac, Adobe PDF Pack. And I would also invite the court perhaps to try any one of them out. Staging, I just want to add that staging is admitted even by Iebc. So it's not, does not lie in the mouth of counsel, belatedly briefed, to deny that there was such a facility. Mr. Maina Wachira Nyaga, paragraph 2 of his affidavit, sworn and filed on 29th August 2022, confirms there was a middleware in the results transmission system. And this is also confirmed by one of our IT experts, Mr. Benson Wesonga, that there was indeed an attack from the position of man in the middle. At page the evidence we produced of the data analysis by George Njoroge in his affidavit sworn on 28th August 2022 and filed on the same day, pages 68-73 of his report, Mr. Njoroge says that the results from the the results from the polling station was between the 9th and 14th of August tallied 137,000 times 137,847 times. On the 9th of August, 38,353. On the 10th, 35,000 times, 574. 11th, 16,291. 12th, 8,357. 13th August, 14,357. 4th August, 24,000 times, 897. This shows that numbers, the same numbers, were being brought back into the system from 34s, new 34s. Otherwise, and trying to find the magic number that would give the first respondent the win. Finally, I would like to make a few comments on the just concluded exercise, the scrutiny exercise, and state that very shortly that despite the good intentions of the court, the servers were not opened. Unless, of course, there will be another opportunity for us to make a few comments. They will? Or then?
Stop any conversation about the report at this stage.
Okay.
We will allow you time to deal with the report.
Okay. I want to say that the evidence that has been presented by the petitioners shows a well-orchestrated and fraudulent scheme that was executed with military precision. Let me agree with my learned friend, Mr. Mahat, on the use of the word military. He says military grade, but I differ with him to say the rigging was executed with military precision, and given the evidence that has been availed, using expert, foreign, and I'm now using another military word, mercenaries engaged for that purpose. I am not surprised that none of those gentlemen I'm referring to as mercenaries have not sworn an affidavit. People like that disappear and leave the country to its own devices. By the grace of God, we have remained peaceful, and I pray that we continue to do so. And finally, I will yield the floor to my learned senior, Mr. James Ray.
Milady, Madam Chief Justice, we would like a clarification from the court whether the replies and responses relate to questions of law that have arisen from our presentation, or whether it is an opportunity for our learned colleagues to rehash their case afresh and to introduce new evidence.
We know what constitutes a rejoinder. It's a response to issues of law arising from the respondent's response. So just to remind Council, it was about responding to matters of law.
Madam Chief Justice, I also rise to take or to request a clarification. The court was treated to a so-called live demonstration. Shall we be given an opportunity? We don't require more than 3 or 4 minutes to indicate that what the court was shown is not true. Because otherwise, this image is now all over the country, a sensational image about forms with the names of people, whereas in truth, that is not correct. All that I would request, Madam Chief Justice, is an opportunity for rebuttal. On the basis that that is new evidence, it was never played, those are not polling stations in the petition, it's totally new. It will be unfair for us to walk away without being given an opportunity to defend ourselves.
Unless the court walks away from the questions that the court asked, you asked for a demonstration of how the staging was done. It was a specific question. And similar questions were asked to our friends to the left. A lot of new material was brought in. We kept quiet because we knew these were questions from the court and that no evidence should be kept away from the court in the search for truth.
What we are doing, and then at the end of it, we'll consider, because we are also checking whether that is new evidence. Yes.
I thank you. I begin by thanking the court for giving me this opportunity to make my remarks as part of the rejoinder for the petitioner. My lords, when I used to be at Alliance High School, every year, Professor Githu is very happy about me mentioning his school. When I used to be at Alliance High School, every year I took part in a school play. Most of the time they were Shakespearean plays. Macbeth, Julius Caesar, Much Ado About Nothing. Can I recover my 4 seconds? Yes, I was saying I acted in every school play for 6 years. And when I became a practitioner of law, I tended to have the habit, every time I would appear in court, to take some verse from those Shakespearean plays, be it a comedy or a tragedy. And one time, S.M. Otieno, from whom I learned a lot as a young man in the practice of criminal law, he told me when I took my seat, did you read the charge? Did you look at the statements? Did you analyze the elements or the ingredients of the offense? Always remember, as a lawyer, that oration is not good enough. Substance counts when you appear before the court of law. And I'm saying this because in 2017, when he had a similar petition before your lordships, some of the advocates who are in that petition, acting for the respondents, when we presented our petition, said that what we presented before the court was a science fiction. And I'm not surprised that even at the beginning, and it's well covered in the media, that what we have presented before you is fiction. And because it is fiction, you had a lot of speeches which I think do not belong to a courtroom. They probably should have been delivered in some theater where people love poetry, like my learned friend, Professor Githu Muigai, whom I know, having attended the same school as I did. We share a lot of things in common. We have presented before your lordships a petition based on averments which are contained in the petition. We have placed evidence before your lordships, and the petitioners did not ask the petition to be struck out. Instead, they filed volumes and volumes of affidavit evidence, and I've addressed you at length on matters relating to the petition. And yesterday, I remember when your lordships and my ladies asked questions to the respondents, my learned friend, Mr. Githu Muigai, said those questions were difficult questions, but they are not as difficult as the questions which were directed against the petitioner. But having said that, there is an important point about this new constitution. And I'm so happy that your lordships and your ladyships, some members of this court, were part of the process of drafting this constitution. And my lady Justice Njoki asked a question which was very pointed Why did we create these commissions? Why did we create these independent offices and secure their tenure in the Constitution? And the answer is that we are dealing with an imperial executive. The commissions became an insurance policy for the protection of the sovereignty of the people. And if you look at Article 249, the commissions and independent offices are required to protect the sovereignty of the people. And what better tool to use in order to protect the sovereignty of the people than to have fair and free elections conducted by an independent body. And this constitution requires that the elections must be transparent and they must be administered in a neutral, efficient, accurate, and accountable manner. I would have hoped that if the Electoral Commission was indeed carrying out an election that was free and fair, transparent, and accountable, they will be offering all the evidence, including what is in the servers, that this is what went on, this is the record, this is the return of the elections that were held on the 9th of August, 2022. I thought that we were making progress. Your Lordships and my ladies, there was a time that we used to file petitions against even the President of the Republic of Kenya under the old constitution. And if you approach the Electoral Commission before you file the petition, you had access to election documents and election materials before filing the petition. And I did that so many times. My other friend Firoz Norji would tell you, because I was a petitioner. And he filed such a petition. Now, to get information from the Electoral Commission, even after filing a petition and an election has been conducted, is like the road to hell. Because that's what it is. And in Article 249, the sovereign, who is the people of Kenya, require of the Electoral Commission as a state organ to secure the observance of democratic values and principles and promote constitutionalism. Not just in the conduct of the elections, but even the way it runs its affairs. They cannot pretend that they're conducting elections and valuing and securing the principles of democracy as contained in Article 10 of the Constitution, and yet within the body itself, they don't value these principles that are not discretionary. They are, every state organ, every person is required to act in accordance with Article 10. What does the chairperson of the Electoral Commission do in the circumstances, not only of this case, but even in previous occasions? In the Electoral Commission, instead of having a commission of 7 commissioners, and you have seen the factionalism here, you have a triumvirate, you have a trioca that is moving together all the time with the secretary of the commission. This is not what the Constitution desired or contemplated. If you look at Article 88 of the Constitution, the mandate of the Commission in relation to the supervision of elections and referenda, at the end of that article, 88, and I think this is important. Sub-Article 5, the Commission shall exercise the powers and perform its function in accordance with this Constitution and national legislation. So that where the chairperson comes before you and does not show conduct that is in consonance with the Constitution, is that a matter that this court can just gloss over? When the Constitution says in Article 2 that this Constitution is the supreme law of the Republic and binds all persons and all state organs, and no person may claim or exercise state authority except as authorized under this Constitution. And throughout that Article 88, the Constitution throughout talks about the Commission, except in two instances, one of them being the declaration of the results in a presidential election. So I urge my ladies and my lords that where there's been an infringement of the Constitution, however good the outcome, but there has been an infringement of the Constitution, because the Constitution says how we should conduct elections. It does not matter whether you get 10 million votes or 20 million votes. If you get it by murder and killing people, if you get it by falsifying documents, however the numbers you end up getting in an election, that would not be the kind of election contemplated under Article 81 of the Constitution. The process matters. And anything in violation of the Constitution, if you look at the Constitution broadly, any infringement of the Constitution, violation of the Constitution in relation to state officers, including the President, including members of commissions, any infringement of the Constitution normally would attract consequences of removal, impeachment, because it's a matter that this Constitution frowns on. And that's why I always appreciate the fact that this Constitution requires of citizens, every person has an obligation to respect, uphold, and defend this Constitution. This petition is in defense of the Constitution. Is in defense of the Constitution because there's an election that has taken place that is putting somebody in office, or is attempting to put somebody in office without meeting the requirements of the Constitution, not only in terms of, not only quantitatively in terms of votes, but also in terms of what the Constitution requires the conduct of elections to be like. And my learned senior, Mr. Firoz Neroji, referred to a football match. These days, football has many rules, and they keep on improving. However many goals you score, if it is from an offside position, whether you're Messi or Ronaldo, it will not count. It will not count. So I urge the court, and I am an optimist. I think we are doing very well in this republic. I think we have come from very far. And as one who has practiced in these courts when things were extremely difficult, I know we are making progress, a lot of progress. There were times to file a petition like this was not easy. And if you file it, serving that petition will be very difficult. And that is not just because of legislation and a new constitution. The courts had made an intervention many times to protect the people against those who govern them, particularly. I therefore invite your lordships that looking at the article dealing with leadership and integrity, what has been placed before you is not a matter that the court can frown on, gloss over. This court said in 2017 in the Raila petition that if the Electoral Commission comes before you with the same kind of infractions and transgressions, this court will not hesitate to take measures against the Commission and its leadership. That is in the Raila judgment of 2017. In 2013, this same Commission, fortunately for the chairperson, he was not there at that time, despite the fact that that petition was not allowed, but the court was not amused by the going-ons in the Electoral Commission, and by dint of the comments that were made by the court at that time, at least a few people were taken to court, although that case is still going on. I think this court, and reading the Supreme Court Act, Section 3, together with Article 259 of the Constitution, which talks to how this Constitution should be interpreted, and more particularly when it says in a manner that promotes the values, the purposes and principles of this Constitution, and contributes to good governance. So I urge this court, with all the humility, that although this is a petition basically under Article 140, as defenders and protectors of this Constitution, you, with respect, cannot allow what has happened at Iebc to go without some kind of action in the lines that was suggested by my learned senior, Firoz Norji. Impunity must be punished. Impunity must be punished. And impunity unpunished breeds arrogance. And arrogance leads to arbitrary exercise of power. And without that being done, this commission, which has got the protection of the Constitution, without the court making some interventions, it still be a divided commission with a triumvirate that runs the affairs of a commission that is supposed to protect and defend the sovereignty of the people. And what I'm saying in a nutshell, that this election cannot pass on account of violation of the Constitution, even by the constitutional dictates how this commission should run its affairs. If they cannot conduct their affairs in the manner dictated by the Constitution, then how can they preside over an election, and that election have some legitimacy to the people of Kenya and to the world? Secondly, and this will be my last point, that if you look at Article 138, sub-article 4. And my learned friend, Mr. Otiende, I address you on this. That requirement for a successful candidate getting 50% +1 of the votes cast is not an idle provision in the Constitution. It requires of the Commission to come with it before your Lordship seriously when there is contestation and put the numbers before you in rebuttal to the case that we have put before you. My little friend, Mr. Mahat, who is also my very good friend, in his address, he was not talking about what the law requires or what the Constitution requires. He was saying, this is what we do. This is what the Kimskits do. There was no constitutional or legal foundation that he was resting his arguments. And therefore, yeah, my ladies and your lordships, I would ask the court to apply the provisions of the Constitution to the letter holistically and allow this petition and return this country and back to the people who are sovereign, and let a proper choice be made of the person who is going to lead Kenya in the next 5 years.
Your Ladyship, Madam Chief Justice, Your Ladyship, Madam Deputy Chief Justice, Your Ladyship, and my Lords of the Supreme Court. The petition that was filed by the first petitioner, to recap it, was a very simple, by the second petitioner, I think we are the second petitioner as amended, was very limited to a legal issue. It was, what was the position vis-a-vis the election and the role of the commissioners? Now, yesterday, and I think Justice Lenola said something about tweeting and stigmatizing, but in a nice way. When this petitioner came, and I had said it in my opening address, and yesterday Mr. Ngatia said, senior counsel said something very, very, I mean, it's our country. He said, this is one country that even the humble can go to the top. But there was a caveat that seems to have been missed out. If you are a normal, humble person who comes to challenge a presidential election as required by the law, you still get targeted as being a surrogate, because that was repeated 3 times. So there seems to be caveats in these things that we don't seem to know about. Yesterday, my lady, Justice Njoki, asked a very direct question. What is the role of these 6 commissioners and the chairman? Because we seem to be getting in a very empirical chairman. This morning, we got absolutely no idea, except the court was taken to Section 11A and B of the Iebc Act. We were told nothing more. From what I can now see is that these 6 commissioners are supposed to be flower girls and page boys at a wedding, with the chairman being the bride or the bridegroom, as the case may be. That surely was not the intention of the Constitution. It appears that that's because I was actually waiting for that answer just as much as your lordship and lordships and ladyship was there was nothing given. Please go to 11A. That's all you were told. We have an umpire, and I'll use it in the cricket term because in football it's called referee. but here in the cricketing terms, it's called an umpire. It is supposed to be an independent umpire. But I heard some very, I was a bit surprised yesterday when I heard words like shock and awe tactics. And surprisingly, the shock and awe tactics actually came out in one of the protagonists, the ones, the protagonists of We've Won, and that was in one of the affidavits. And these are the direct words that an umpire is using. So how is this umpire as independent as they are claiming to be? That is my, that is my client's case, that we need an independent body. The second one, we were told by the umpire, get over it, quote, unquote. We were told by one of the protagonists, move on. If there has been a breach of a constitutional, and as it has been our submission, Article 138, 3C, if there is a breach, do we just move on? That's what we are being told. Forget the transgressions that anybody is doing. Justice Lenola, in the opening day after the petitioners had made some submissions, asked a question which I didn't see anybody answering. He asked a question regarding Regulation 87.3, where he had stated that if it should be struck down, but it's already been done. So, that was the regulation which was in place. If your lordships and your ladyships will look at my submissions, my original submissions we had filed, and we specifically addressed that issue. What is a nullity is a nullity, and I believe it is in the McFoy case, it's an English authority, that we have quoted in our original submissions. So I hope, Justice Lenola, it answers your question.
Thank you.
Because I think nobody here actually took those questions seriously, they didn't answer them. And I don't mean to be disrespectful or being facetious at all. As far as from what I can see, is that this, by the law, by Article 138 3C, it says commission. We were told commission, but it doesn't say commissioners. That was a distinction being made yesterday. It says commissioners, doesn't say commissioners, but commission. With due respect, all those commissioners are appointed, well, not at the same time, but go through the same rigorous process. Does it mean all animals are equal, but some are more equal than others, which means the chairman is more equal than anybody else? These, like I've said, and I repeat again, are just flower girls and page boys. That surely cannot be the intention, could not have been the intention of people who drafted this constitution. We go back to where we started from, and I've said that in my original submissions. Where did we come from? We need to know where we came from. One-man show? Surely that cannot be the issue. The other issue that the Chief Justice asked yesterday, why was it not declared to everybody? And that's where my client, that there were all these problems, these commissioners had walked out, the transparency, accuracy. Nobody has given us that answer as we sat through this today. You specifically asked, Madam Chief Justice, why was it not declared that there were these problems, 27 constituencies? Nothing. We couldn't do it because there was a problem. I don't want to go into Maina Kiai case, but you were quoted paragraph 287 of the Supreme Court, which I called Raila, which was Raila 1 or 2. But please, before just looking at 287, please look at paragraph 292 of this court's decision. I don't want to repeat it, but this court specifically said, it is in my original submissions, we fault the appellant, who was the Iebc, and the chairman, who was the current chairman, for there being no verification by the commission. We've been told we've misread the section because it's polling stations. With due respect, if it was going to be only polling stations, why send it to the National Tallying Center? It is for the public to know there were mistakes here, there were no mistakes, whatever else there was. A question was asked by the court yesterday. Why did the running tallying stop? Nobody's given us an answer. All the difficult questions that we were to get answers for, to which my client, as a voter and as Wanjiku, I keep on saying, we have not received any answers whatsoever. No affidavits. In fact, the sad part is, despite this whole matter being consolidated, we were considered the surrogates. Nobody sent us any papers to sign. I have two requests from this court, as I have said, and this was what I was thinking of last night before I went to bed. Where it is established that a state officer is subverting the Constitution and the rule of law, the court's hands are not shackled by procedural niceties. This is the beauty of this Wanjiku Constitution that we have. It's transformative, and some people say it's a very overused word, but in these circumstances it's ideal and can bite when occasion demands. The toothless bulldog is long dead and buried. Please, Madam Chief Justice and honorable judges of this court, bite and bite for the glory of this court. And in closing, whilst we were told our petition is much ado about nothing, and like I said, we've really been battered, but we shall soldier on. I will use Martin Luther King's words, because I suppose, unlike Professor Guido Muigai and Mr. James Orengo, I went to a school where they didn't teach us Shakespeare, they taught us Things Fall Apart. They went to the posh schools. And all Martin Luther King said in 1968, at the speech given at the National Cathedral, we shall overcome because the arc of the moral universe is long, but it bends to justice. That's all we request. Can we have justice for all of us, for the voters? Because the two parties just think about themselves. They forget us, who are the voters. Thank you. And I donate my 4 minutes back to the court.
Thank you. We will have the third petitioner, Youth Advocacy Africa, and Peter Kireka.
Madam Chief Justice and Madam Deputy Chief Justice, and may it please the members of the court. Yesterday, and for a section of this morning, Your Ladyship, I believe we've been allocated 30 minutes. I see the clock says 15. The directions clearly said 30 for us. Youth advocacy.
I don't know whether there was any question directed to you.
Yes, there were. But the direction said 30 clearly.
No, the directions I have.
Yes, for youth.
Yes, for youth advocacy is 30 minutes.
30 minutes, yes. I think the clock said 15. Yes. I was a bit concerned, yes. But for yesterday, for most of yesterday and this morning, members of the court.
Sorry, Counsel.
Yes.
For our record.
Yes.
Introduction.
Yes, Your Lordship. My name is Tom Asharia. I appear together with my colleagues on record for Youth Advocacy Africa and Peter Kireka. Most of yesterday and this morning, you are treated to the theory of an election as it ought to be conducted. My colleague, Julie Soweto, has demonstrated to you what every Kenyan knows. Mambo kwa ground ni different. I call your attention to the affidavit yesterday presented by my good and learned friend, Professor Kindiki, which has been projected. It's the affidavit of Veronica Ndwati. She deposed that she is the Secretary General of United Democratic Alliance and was the Deputy Chief Agent for the 9th and 10th respondents. In particular, I call your attention to paragraph 7, where she states that the verification process went through a 3-tier mechanism. At paragraph 7, she says the second tier was at the constituency level, where the following actions were undertaken. She then goes to subparagraph C, and that is the one of interest here, and this is what she says. In case of any errors, this is at the constituency level, on Form 34B, the same would be corrected. That is the key. Those are the key words. She then goes on at paragraph 8 and says that the third tire was at the National Tallying Center at Bomas of Kenya, where the following activities took place. We go to paragraph 8F. The verification team would also verify that each of the uploaded Form 34A in the public portal is a replica of the original 34A presented by the constituency returning officer, and in instances of discrepancies, the errors were noted. She then says at G, the team would also verify that the data entered in the Iebc online system for purpose of tallying from all original forms was correct. In case the data entered in the Iebc online system is incorrect, the same was corrected on the online system. She then goes at J, a verified Form 34B would thereafter be generated at Bomas. Another one, having corrected at constituency, another one now is generated at Bomas and supplied to the candidates' agents. I specify these particular provisions because, members of the Honorable Court, this is precisely what the chairman of Iebc was told in the minor KI case he could not do. And it bears reading because, as has been repeated here severally, and perhaps I shouldn't repeat it too many times, he is qualified to be a Supreme Court judge. And so we know he understood minor KI. So it is important that we understand what he did not understand about the following passage. It is evident, I'm reading from minor KI, it is evident to us from the above sequence of events that the role of the chairperson of the appellant is circumscribed. Article 138 deals with events at the polling stations where votes are counted, tallied, verified, and declared. The appellant, that's the commission, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for election of president, electronically transmitted to it from near 40,000 polling stations, is required to tally and verify the results at the National Tallying Center without, this is the key word, without interfering with the figures and details of the outcome of the vote as received from the county tallying center. Minor KI states further, the chairperson, on the other hand, is appointed under Article 250 of the Constitution. The chairperson cannot be and is not the commission. It goes on to say, and I say this because my good friend George Morogo this morning told you that whether the chairman is the commission or the chairman is a matter of context. It is not a matter of context. Minor KI put that debate to rest once and for all. And finally, to suggest that there is some law that empowers the chairperson of the appellant as an individual to alone correct, then that's the word, correct, vary, confirm, alter, modify, or adjust the results electronically transmitted to the National Tallying Center from the constituency tallying centers is to donate an illegitimate power. Such a suggestion would introduce opaqueness. These were the words used by the 4 commissioners who disagreed with what was going on at Bomas. Opaqueness and arbitrariness to the electoral process, the very mischief the Constitution seeks to remedy. I don't know how much clearer it can get that what the chairman of the commission did was the very opposite of what the Constitution required him to do. Now, minor KI was itself based on several decisions of this court. The first of those being Wanjohi, which is a 2014 case, and it is cited there, where the court said, apart from the priority, this court said, apart from the priority attaching to the political and constitutional scheme for the election of representatives of governance agencies, the weight of the people's franchise interest is far too substantial to permit one official or a couple of them, including a returning officer, unilaterally to undo the voter's verdict without having the matter resolved according to law by the judicial organ of state. The only organ under our constitutional framework permitted to correct at any level, let alone any of the three levels that the chairman of the commission undertook, is this court. It is manifest to this court that an error regarding the elector's final choice, if indeed there is one, raises vital issues of justice such as can only be resolved before the courts of law. We reiterate as we conclude that there is no doubt from the architecture of the laws we have considered that the people of Kenya did not intend to vest or concentrate such sweeping and boundless powers in one individual, the chairman of the appellants. Now, as we stated, the chairman is an eminent lawyer, qualified to be a Supreme Court judge. It is extremely unlikely he did not understand what Maina Kiai had told him. And the only reason he would then have proceeded in the manner that Veronica Nduati tells us is that, to use another Kenyan phrase, mtadu, what are you going to do about it? That is the only reason one can find for what he did. Yesterday, the commission came and told you that the system was accessed thousands of times by officers at the Bomas. And so clearly, you had returning officers, specific special returning officers, assigned to changing forms on the portal, as has been demonstrated this morning. In our submission, the alterations made to this system, to the forms, these so-called corrections that were done at three levels, so alterated and contaminated the outcome of the election that it is now incurably defective and incapable of being rescued. Now, we were challenged to demonstrate from their own forms what the problem was with the forms. Now, time doesn't permit me to take you directly to those affidavits, but the commission has filed an affidavit through the firm of Iseme Kamau and Maema in our petition, the affidavit of Esther Wanjiko Wanjohi. She attaches 14 forms. That's about a quarter or 30% of the forms that you asked to be taken through the scrutiny. Of those 14 forms, 8, representing 57% of the forms, 8 have irregularities, have gaps, have problems, including the fact that when you read them with a QR code, the serial number that shows up is for a different polling station. The problems are correction problems, tallying problems on those forms submitted by the commissioners themselves, by the commission itself. You have an affidavit submitted again by the commission, the affidavit of Nzika Mwololo. Same problems. He has 2 forms. 50% of them, which is 1 form, has an incorrect addition where the rejected votes have been added as part of the total. Now, in light of what Maina Kiai said and what my learned seniors have said here this morning, my mind is taken back to a few months ago when a few of my colleagues here, my good friends here, came before this court and told you and persuaded you that a process known as BBI, one where 1 million signatures had been collected, one which had gone through over 40 county assemblies, one which had gone through both houses of parliament, was irredeemably void and null because the president used the wrong process. And they persuaded you. And I invite you to look at paragraphs 1544, 1535, and 1500 of your judgment in the BBI case, where you stated that any process, any activity undertaken without constitutional authority, as the chairman of the Iebc has done in this particular case, must be declared null and void. And the terms null and void, and this is one of the cases we've stated before you, the case of McFoy versus United Africa Company, is captured in the following words. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have a court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. That is the fate the Form 36, the Form 34D, issued by the chairman of the commission in this matter, must suffer as well. Now, my learned friend, Mr. Mahat, has taken you through some numbers. And as I've demonstrated, and as was demonstrated earlier here by my colleagues for the first petitioner, when you have a process where the numbers are so adulterated, where the forms are so compromised, what numbers are we talking about? Numbers that have been verified or quote-unquote tallied in an unconstitutional matter. Our learned senior, I think Mr. Orengo, I think it was Otinda Molo Senior Counsel, said that the numbers became a moving target. Now, in fact, they were behaving not more like a moving target, but like a group of naughty children in a nursery school running around the yard. It is impossible to get a hold of the number that was used either for the 50+1 or for the tallying or for the verification, which, as you have heard, was changed 3 times. Now, you asked, I think, of the petitioners, how did we get to this place? Like every slow train crash, a train crash in slow motion, those of us who lived through the repressive days that led to the Constitution of 2010 will tell you that it did not happen one day. My good friend Mr. Morogo has told you that the Gazette notice by which the chairman appointed himself as the presidential returning officer. And we need to note, because the defense put here yesterday by the commission, was that he appointed himself on the basis of your judgment in 2017, where in passing, you said that there is a national returning officer. Now this year, he has upgraded. He upgraded himself to presidential returning officer. Now you've been told that Gazette notice means nothing. And I think yesterday you were told we ought to be grateful to him because he had the good grace to publish in the Gazette his unconstitutional appointment. Now, whether you publish misconduct in the Kenya Gazette or you publish an offense does not imbue you with some sort of value or does not imbue that process with some good grace or quality if the Constitution does not permit that office to exist or does not permit him to conduct himself in the way it did. A Gazette notice does not improve it. But perhaps more importantly, if it meant nothing, why publish it in the first place if it meant nothing? Why publish it at all if it meant nothing? But the point I wish to make is this. Complaints were raised. I think I've seen letters written by the party that nominated the first petitioner. There were newspaper articles complaining, Gazette notices, newspaper notices complaining that ballots had come without commissioners being told, but you'll get to hear that a bit more. There were complaints made by civil society. But as happened with Kenya, when we ended up in the position we ended up before the 2010 Constitution, we keep pushing these things away to the back of our mind. And people go to campaign, the rest of us go on with our lives, and he publishes a new Gazette. I am now the presidential returning officer. He goes on ahead and does other things, allocates duties. You go look after flowers, you go be an usher. These are slowly and then progressively, we end up with what was this morning called an imperial chairman of the commission. And so this is how we ended up at this unhappy day, where 4 commissioners say that we cannot stand by these reasons because we were not involved in everything that was done with them. But apart from that, and apart from those obvious misdemeanors and indiscretions that have been pointed out here this morning and the day before yesterday, in our petition, we've raised the fact that even other statutory requirements, the KPMG audit report, for example, was only published on the 5th of August, 4 days to the election. And parties kept asking for this report. Where is the report? And we'd all be told, again, in that most Kenyan fashion, tunashughulikia hiyo maneno. So you go back and campaign, go do your things, and you wait. And on the 3 days before the election, it is dumped on the website, and no one is actually told. There was no press release saying, we've released KPMG now. We had to find it there by accident. Now, when you finally go and look at that report, and you'll see a copy of it in the particular pages I refer you to, pages 1,153 and 1,155 of the petition, you will find that KPMG complains that both the Commission and Smartmatic withheld critical information as regards how the voters register was being accessed, and that by the time the report was written and released, they had not received that information. That was the KPMG report. Now, again, the Commission comes here this morning and tries to explain to you how they arrived at the question of voters identified with the printed register. One of the things you will not find in the affidavits filed by the Commission is an account of how many Form 32As were signed as required by law. And that is the only mechanism that the regulations identify for identifying those who have voted outside the KIMS-KIT system itself. And so what they've done, and that's what I think one of the honorable judges yesterday called a bit of a lecture here yesterday, is do reverse mathematics. You begin by adding up all the votes you say were in the Form 34C, and then you subtract from that those who were identified using the KIMS-KIT. You have not been given a report of how many Form 32As were signed. In addition to that is the tortured question of Regulation 69, Sub-Regulation 1A. And I've not had anything said about that here. Now, Regulation 69 1A of the Election General Regulations requires that every time a voter is identified using the KIMS-KIT, the printed register must be crossed out. And this is not a function of voter identification. This is an audit tool to ensure there's no fraud. A distinction must be made between what was before the Court of Appeal in the case raised before you about the printed register and what the law requires as regards the crossing out. For some reason, the Commission strenuously opposed this audit tool. Now, you've been told that there were approximately 92,000 stray ballots. Now, the mathematics that the Commission chair uses to arrive to that number, for starters, is not an accountable figure. What they've done, and you'll find that, I think, at paragraphs 73, 74, 75, and 76 of the chairman's replying affidavit in our petition, is taken two constituencies, this is Makadara and Kibra, and said that in those two constituencies, we had an average of 2 stray ballots per polling station. They take an average. And the reason for this is that it is not possible to account for stray ballots in Kenya within the time that this court must rule. Because under Regulation 81E, once stray ballots have been identified, they are put in an envelope, and neither Form 37B, 38B, or 39B have anywhere to indicate stray ballots. They are indicated in a polling station diary. The only way of arriving at a precise number of stray ballots and identifying to whom they strayed, if I may use that word, is to audit the polling station diaries for the 46,000 polling stations in this country. And that hasn't been done. And so we can't speak with any certainty here when a figure is thrown at this court that there are 96,000 or 92,000 stray ballots. No one knows. The truth is that no one knows. That's number one. The second thing is that in arriving at these mathematics, the chair of the commission says that in six polling stations in Starehe and Mathare, the officer locked up the forms in the ballot box. And he then says that in the 6, we cannot account now for 4,200 ballots. Now 4,200 divided by 6 is 700. What he's saying is that in those 6 polling stations, there was a 100% turnout. You will see that at paragraph 74, 75, 76 of his replying affidavit. Now, when you go to the forms on the portal, as we've been asked to do, the turnout is not 100%. And so that is a false averment in his affidavit. I think much has been said about the forms and the PDFs. I think I won't venture to say anything about that. I think I should also state, because it was part of our petition, that by the time we went to the election, and I think as of today, an audit report as required by the elections technology regulations has not been provided or done. It's not on their website, it's not been provided. The elections technology regulations under the Elections Act require an annual audit under Regulation 10 and 11. You will find in a response by the chairman to the first petitioner's party a letter where he says we could not do the audit because we did not have money. He has now annexed, in response to our petition, a certificate, a 2-page certificate, where they say we have 10 reports, but he doesn't attach those 10 reports. They are not on the website, and we have not been provided with them as of today. The purpose of that audit is that it might become impossible or unnecessary for us to spend time here discussing things called logs. And the only logs my grandmother knows are those she uses to warm herself. And yet she's the voter. We must, and I think we've submitted before you a case from the German Constitutional Court, which states that unless the public is able to, independent of an expert, audit the process used to conduct an election, then that election is not verifiable. That decision is before you with our digest of authorities. And it speaks to something a bit more nefarious, if I may use that word. We have just been told here today that we had foreigners who have accessed our IT systems. I can't pronounce their names on account of my county of origin. Now, and what has happened is that, and the submission I would make, is that the Iebc ceded control of the process of determining the sovereign will of the people of Kenya to a foreign entity that now says that that data is the intellectual property and cannot be shared with Kenyans. And there are very, very serious questions that arise. And I say this because they were asked of the chairman of the commission. For example, this data, they now say is theirs. Has it complied with the Data Protection Act? Was this company subjected to the provision of Section 31 of the Data Protection Act? And what are the consequences of surrendering our data, our biometric data, to foreigners who now tell us that is now their intellectual property? And I think Kenyans would be forgiven for saying that we're going soon to have leaders made in Venezuela, not in Kenya, not by Kenyans. Allow me to use the few minutes left to address some of the questions I think you raised, especially as regards remedies. But before that, let me just point out that amongst the other failures by this commission was to provide the Parliament of Kenya with amended regulations, which they promised to do last year, but presented amended regulations in June or July as Parliament was going on recess Sendai. And so again, they'll come and tell you the law was not amended for us to rectify some of these things, but they submitted their proposals late again and outside the election operations plan that they had said they would do. Now, printing of ballot papers. A specific question was asked of them. This company that you have procured, rightfully or wrongly, is accused of having led to the postponement of an election in Nigeria. And the chairman again said, there's no problem, tunashughulikia hiyo maneno. On the 8th, we have the largest postponement of elections in the history of Kenya. The elections postponed on 8th August was the largest number of postponements in the history of Kenya. So what should we do? Kenyans who run into problems and who find complicated issues they don't know what to do with, I always want to say, do something. Can somebody do something? Somebody should do something. That is what we say. But this honorable court has the power to do something. And it has power to do something even in the face of an imperial commissioner, chairman of the commission, who quite casually says, Mutadu, do something. You have power under Article 140, and again, in my view, I think the question was asked here about the utility of Section 80, subsection 4 of the Elections Act. Now, I think given the time limitations that this court has to do a recount and a retally properly, that section is one that is not very helpful or useful. The requirement of the Constitution under Article 140, sub-article 3, is for a nullification of an election that is found not to have been in compliance with the Constitution. That is number one. Number two, I think the judges asked of us, what is to happen if we are to then find that this chair violated the Constitution or committed crimes? Again, that is a question that has risen here before. I think in 2017, we have an Election Offences Act. We have Article 251, which make provision for what is to happen to errant and imperial officers, public officers, such as the one whose case is before the court today. And so I think it would be premature to start anticipating what were to happen, because I think our Constitution has sufficient, and I think we must trust it. We must trust our Constitution and the mechanisms it has created under Article 140 and other articles for what is to happen in that eventuality. Madam Chief Justice, Deputy Chief Justice, I want to thank you for the privilege of your attention. And unless there are any questions left for me, I will donate my 1 minute back to the court. Thank you very much.
Thank you. 15 minutes given to the fourth petitioner, Khalifa.
My Lady Chief Justice and the court, may I plead with the court once again that what we are listening to is not a reply. It is a rehash of the case afresh, and it is leaving us in a very vulnerable position because new issues are being raised, and we have had, or may not have, unless you assure us, my lady, that we will have an opportunity to reply.
I think we have already cautioned counsel to reply on points of law, and you can see all of us are busy. We know what are points of law in our reply, and we know what we ignore.
Madam Chief Justice, only 2 seconds. You said that earlier. We all thought we had. Despite that, Mr. Mashari has taken 30 minutes to argue factual issues, going to affidavits, nothing on a point of law that he responded to. In my submission, therefore, the court will be perfectly entitled to disregard every word he uttered.
Yes, we know how to separate the chaff from the wheat, from the submissions. Yes.
My lady, before I start my submission so that my time doesn't run, I find myself in the position, I'm Willis Otieno for the fourth petitioner, in the unfortunate position that I'm one of the most mistreated petitioners in these proceedings by the first and second respondents. They served me late, as I indicated already during the pre-conference, and we lost the opportunity to respond. And this court did indicate that when we'll be doing our response, we can comment on some of those issues. We never filed a rejoinder to them because we were the ones who were served late outside the timelines provided by the court. So, but I don't intend to go deep into facts, but I may make one sentence references just to meet what had been allowed before, if that is in order. Number one, my lords and my ladies, we must assert that the KPMG report, the only expert report that has been done on the biometric voter register, that evidence has not been challenged by any other expert evidence. And that evidence which we annexed and we referred to, we can now safely conclude that the 481,711 deduplicates that are in that report, 481,711 is admitted. The second point that I wish to respond relates to the question my learned senior Professor Gidu Muigai said, that if these elections were badly conducted, not in accordance with the law, what about the other 5-tier elections where we have governors and senators? One answer, jurisdiction. Every court will have its day, every court will consider the facts of those cases. The third point that I wish to respond to relates to what was asked of when the regulations that gave the chairman the power to be a returning officer were passed, they were law at the time he acted. Simple answer, Maina Kiai case had already answered that question of what the law was. Maina Kiai case had interpreted Article 138(3)(c) of the Constitution. That was the law, and any regulation being made to circumvent that law by itself is unconstitutional. As I said, Helef was a petitioner in Maina Kiai case. Helef came to court. Helef has come back to court to enjoy the fruits of his litigation in Maina Kiai case, and I was his proud lawyer in that particular case as well. My lords and my ladies, reference was made that the Iebc saw the ballot boxes for the first time that necessitated the postponement of the elections on the 8th of August. My lords and my ladies, Lycos never disappoints. You've just been told how Lycos, wherever they printed ballots, they've always ended up with postponed elections. Iebc should have exercised due diligence to make sure that even the pre-printing images are cross-checked and confirmed to be accurate. An admission that I submit is that Iebc was not diligent and it must pay that penalty. It cannot transfer the consequences of their lack of diligence on the people of Kenya through fake elections. My learned friend, Mr. Gumbo, spoke on technology, and he gave us the Kriegler report. Kriegler report did not say deploy weak and vulnerable technology. Kriegler report required you to deploy sufficient, efficient, integral technology that protects the will of the voter. Kriegler report did not make a recommendation for Jose Camargo, Diego Maradona midfielder, to sit in the middle and start distributing results, as was demonstrated today in the morning. Kriegler report is not an answer or does not excuse a technology that the KPMG audit report has found and confirmed to be vulnerable, has 14 unauthorized users called Embakasi South clerks. The fourth point I want to raise is Iebc has confirmed that we look at the portal to tally the results. It is not the public portal that is used to tally. Tallying is a function of the commission. The commissioners must perform a tally of those results. And what is the commission vis-a-vis the secretariat? I refer this court to the case of Engineer Michael Kamau versus EACC, where the court specifically said the core functions of a commission cannot be performed by the secretariat. That was the Court of Appeal decision. It's part of the bundle of documents that we've annexed. You are told, my lords and my ladies, when in relation to the question of how integral the technology was, and my learned that Justice Lenaola did ask, when you take a JPEG and it comes out, as a PDF, and I tied to the response what Kamago was doing in the system. And my learned friend Samane said, he's a plumber. He's like a plumber maintaining the system. Let me say this. Once a plumber has fixed your bathroom, that plumber has no business being in your bathroom when you're showering. If you find him at that time, you tell him, get behind me, Satan, as was said in the book of Mark 8:33 in the Bible, when the devil entered Peter, and Jesus told him, get behind me, Satan. A plumber who is in your bathroom when you're showering after fixing your shower is no longer a plumber, is a sexual offender and should be reported.
Let's stick to the...
I'm guided. Mr. Somane took you through several forms, explanations, trying to explain what is voter turnout, the Kim's kit. At the end of the day, when you leave, are you able to answer the constitutional threshold, the question, are those results, is that system of technology simple, verifiable, and accurate? Why the many explanations? Why the kizungu mingi? It should be simple, accurate, and verifiable. What we've been shown is not simple, is not accurate. This court is still left with so many questions as to the true Kim's kit logins, as to the true and exact turnout of voters as at 5 p.m. on the 9th of August. You are told that parties must have their own agents to present things here. My petitioner is not a political party. He is not a candidate, but is a voter entitled to participate in elections and to present a petition. The obligation, legally speaking, is on Iebc to provide a free, fair, and verifiable election. There is no obligation on a voter like Hele Khalifa to hire and recruit agents all over the country to watch how the elections are conducted. If you do so, then you will forever relegate the participation of the people of Kenya in a free and fair election to the ability to hire and deploy over 46,000 agents in all the polling stations to watch over their vote and the votes of others. The question was asked, the question was raised by Mr. Ngatia, that election officials are tired, they need to go back to work. Convenience again. I say this. Our constitutional values and provisions should not be sacrificed at the altar of convenience. If the election officials are tired and cannot do another election, please, we have more Kenyans who are willing to do this work properly. Give them that opportunity. And that ties to the point that was said, that Kenyans cannot be in elections in perpetuity. Kenyans must get it right. And I say this with due respect to this honorable court, that the Supreme Court has a higher obligation when it comes to this issue, to ensure that we get what we call regime legitimacy. In countries like DRC, once a presidential election is concluded, it goes to their Supreme Court, the Constitutional Court, to get a validation, regime legitimacy. That is what Helef is questioning here. In a fractious society, highly political like this, just remove that, highly political like this, a Supreme Court's decision gives regime legitimacy to that new regime. And when questions are raised like we've done, then the Supreme Court, and when you consider the margin by which the purported declared winner has surpassed the victory, that legitimacy should not be granted by this court at this point. I want to address a few questions that were asked by the learned judges. Number one, by Justice Ibrahim, is there a lacuna in the law if we nullify, in God's grace, these elections? And, if we indict Wafula Chebukati? The answer is very simple. Article 142 of the Constitution, the president who is in office shall continue in office until a new one is sworn in. There is no lacuna in the law. The second point, Mr. Chebukati is not immortal. He could even resign from his office. Does it mean that this country can collapse if Mr. Chebukati resigned from his office today? No. elections will still be held. We'll still have within our governance, we have a working parliament, we have a national executive, we have a judiciary. All these questions, all these issues can be addressed within those existing parameters. And when I say the president will continue in office, of course, within a narrowed mandate, but the systems and the functions of government will continue. The lacuna will not affect the people of Kenya. The right thing is to make sure that the people's voices are actually heard in a true, transparent election. My learned Chief Justice asked the question, why it took too long, why the Commission did not announce the results from morning. To corroborate that there was actually peace at Bomas, we had a choir singing the whole night and the whole day. If there was violence as was being presented here at 3 p.m., what stopped them from announcing at night those remaining polling stations, constituencies? What stopped them from announcing those constituencies in the morning? The choir is my witness. They were singing, there was peace, and everybody saw that. The other question that was asked by learned Justice, Deputy Chief Justice, about a dysfunctional commission, I wish to say this. The dysfunctionality of the commission has always been there. But it has been brought to us by what I call a celebrated group in this constitution. In 2007, Kipkirui, an individual clerk, came out and told us what is happening at KCC is cooking. In 2017, Roslyn Akombe came out and said, what is happening at Iebc is not being done in compliance with the orders of this court. And she ran away, she fled this country. In 2022, you now have the commission itself, by a majority of its members, coming out to tell Kenyans that what is being announced are not the product of the commission. Should those commissioners be vilified? Should a commission that has made an admission of a failure of Tier 3 be vilified? I say no. That dysfunctionality should actually now prove to you that indeed the Constitution is working. On the question that I wish the court to consider, what would have happened if we didn't have this court? In 2007, we didn't have this court. And those who had been said to have lost the elections didn't want to go to court when they were asked to go to court. Because to serve a president was almost impossible. The hearing of the petition would have taken forever, even 5 years, the entire term. This court should not leave Kenyans in a way that they start questioning themselves, do we still have an avenue through which we can solve these political questions? That is a core function of this court. If the court fails to stand up to occasion, the ramifications on the people of Kenya will be dire because people end up losing trust. So I urge you that do not err on the side of convenience to tell the people of Kenya that when we can see some of these problems, convenience requires that Chebukati cannot conduct an election within 60 days. Let us not upset the elections. It will erode public confidence in this particular court, which will be catastrophic as we witnessed in the year 2007. Tied to the commissioners, there are affidavits, and I believe the commission will talk about them. In their reply, the majority commissioners in their replying affidavits have already, we must point out, number one, that these commissioners have been in office for less than 1 year. September marks their first year in office. Within that 1 year, they've filed they've written 3 memos on the conduct of the chair unilaterally making decisions. Ultimately coming out on the 15th to tell Kenyans what they had been dealing with internally of a unilateral, arbitrary, all-knowing chairman. And I say this as I conclude, my lords and my ladies. When an alligator comes out of the water and tells you that the crocodile is sick, do you doubt him? When the commissioners come out and tell you that our processes are opaque, our processes are not as per the Constitution. Do you doubt them? I urge you, don't doubt them. We pray, my lords and my ladies, that you allow the petition as prayed and grant the orders which are sought, and don't shy away if you find it necessary to indict Mr. Wafula Chebukati for the transgressions and the singular manner in which he has run the IEBC to the detriment of Kenyans. Thank you very much, my lady. I yield today 13 minutes of my time back to court. 13 seconds.
Thank you. Counsel representing the fifth petitioner, David Kariuki-Ngare. 15 minutes.
Your Lordship, the Chief Justice, Deputy Chief Justice, members of the court, may it please you that my name is Mamboleo. I represent the fifth petitioner in the consolidated petition. We will be making this rejoinder together with my learned friend, Mr. Murara Umoke. Your Lordship, when we filed this petition, the response we got from the respondents was that this petition was frivolous. The other response, my ladies, my lords, was that the tallying, verification, and declaration of results at the National Tallying Center is a preserve of the chairperson of the commission. That the rest of the members of the commission have absolutely no role whatsoever. I can quote my senior colleague, Mr. Kamau Karori, as deliberately insisting that the other members of the commission, the 6, don't have a role. That in fact, the chairperson of the commission has been extremely magnanimous because at various points in this process, he's even involved them somewhat. The third response we got is that the election of the President of the Republic of Kenya is just about numbers. It is numbers, numbers, numbers. And then lastly, the respondents wanted to put this court in a dilemma, a catch-22 situation, by suggesting that should they exercise some powers under Article 140 of the Constitution and probably nullify the election, we are going to get into a situation that is uncharted constitutionally. Create fear. Your Lordships, your ladies, I want to suggest to this court, when you retire, to look at what we call the theory of false dichotomy. The theory of false dichotomy is an informal fallacy that is based on a premise that erroneously limits the options that are available. And what the respondents are telling you is that the Constitution does not provide mechanisms to deal with the situation that might arise for something that is expressly provided for under Article 140 of the Constitution. I also want to suggest to you, my ladies, my lordships, when you retire, to look at what came into the open about 3 years ago, which is called the CIA Rule Book on Disruption of Organizations. How do you disrupt organizations so that you do not have an organization working as it should? And when you have achieved that, then you come out and use the law to subvert the will of the people. On Bomas on the 15th of this month, of August 2022, it is now judicially noticed that the beaming of results stopped. It is now in public notice that commissioners of the commission, at least 4 of them, came out and stated that they do not have anything to do with the result that was being announced. It is actually admitted that as this was happening, top in the mind of the chairperson of the commission, he knew and understood the process of tallying, verification, and results to be his own precept. He's not even refuted it. He says that is how he understood it. He said that the other commissioners had no role. So what do we want to suggest to you, your lordships, your ladships, It is a very simple thing. That the reason why Kenyans were so glued to the television sets for almost 6 days is because the election of president is the only one thing that Kenyans do as a collective every once in a while. It is so important to them that you simply cannot joke about it. The reason your lordships and every Kenyan was glued to media stations for the 6 days is because you wanted to know what happened to your vote. So Article 138(3)(c), as read together with Article 38 of the Constitution, is, in my view, an expression of the greatest protection or the greatest gift that this Constitution has given to the benefit that is promised in Article 1 of the Constitution, that the people are sovereign. But if somehow you manage to capture the sovereignty of the people and set it aside by some scheme or something, then we are in a problem. And without taking too much time, because I associate myself with the submissions made by my learned senior counsels here, the important thing that we want to suggest to you, your lordships, is that when you retire, could you kindly borrow something that I know you already know, that Article 138(3)(c) of the Constitution is the ultimate protection that Kenyans have been given with respect to the presidential vote in a presidential election. And if you do so, then I'm sure you will come to the conclusion that Article 138(3)(c) is a peremptory norm of the Constitution. It is a jus cogens norm of the Constitution from which no person is allowed to derogate. Not the Iebc, not the chairman, not the President of the Republic of Kenya, and by no means, not even the Supreme Court of the Republic of Kenya. That this court must enforce the fact that this is the highest Grundnorm with respect to the protection of Article 38 and by extension, the sovereignty of the people of Kenya. I will yield my remaining minutes to my colleague, Murara Moke. Thank you.
Second hand? You look second hand yourself right now.
Mimi nakaondiek. Niangalie hivi, nakaondiek.
Not with those. Maybe with the tummy. No. But
Tosha.
Who hata tujuani? Do you know me? Are baba. We know each other. Iko saying lines hapo.
When husband ama ni houseboy? Houseboy. Nini wewe ila kusumbua?
Makoha.
Yes.
Jambo.
Fine, thank you. Oh my God. No. Let me talk the truth and accept the devil, please. Please.
Babyface.
Yeah. Oh my God. Like that. Yes.
Babyface.
Yeah.
Ulionaje kazi yangu, skills zangu za uzaji zikoaje?
You are excellent.
Wewe mzee. Hatuko hapa mchezo.
Ni kweli vile hata nani.
Sasa ukisha si uongee vile unaongea.
Mtu akiwa serious, akwe serious.
Life cannot always.
My Lady the Chief Justice, the Deputy Chief Justice, and the members of the Supreme Court, it's indeed a great honor to appear before you in relation to this petition. My role today here is to take you through the numbers. I will take you through the numbers. The numbers will be running on the screen.
Your name, please.
My name is Mahar Somane Advocate. My name is Mahar Somane Advocate. I'll take you through the numbers as it relates to the petition that has been filed. I will also give you an audit trail of mechanism which the court can use to measure the petition. The first question that I'll answer today relates to the question that has been put to us. And the first one is whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kachaliba, Rongai and Pokot South constituencies, and electoral wards in Nyaki West, in North Imenti, and Kwanjenga in Embakasi resulted in voter suppression. The allegation of voter suppression due to postponement of these elections is not a question of hypothesis. It's a question of fact. It's a question of numbers. What I have done is we have gone through the numbers to give you a comparative data on whether the same is true. The first one, as it relates to Kitui Rural, we have gotten the data for the constituencies in Kitui. Your Ladyship, if you look at the constituencies for Kitui, the voter turnout for Kitui Rural was 60.29%. So for us to actually make a comparative data and analysis to actually see whether there's been voter suppression, we look at the constituencies nearby and see the data we are getting from the constituencies nearby, whether the inference can be made by this court that there has been voter suppression. The voter turnout for Kitui Rural is 60.29%. I have highlighted in yellow in your screens. It is comparatively similar to the voter turnout in Kitui Central. In fact, it is Kitui Rural is higher. Kitui Central is 60.10. It's comparative to Mwingi Central. So to the question the court asked, whether there was voter suppression in Kitui Central constituency because of the postponed election, the answer is an emphatic no. I will go to the second question. The second question the court asked is whether the postponement of elections in Kachaliba and Pokot South led to a voter suppression that led to a low voter turnout in favor of the petitioner. The answer is data-based. I have provided the comparative analysis. I want the court to look at it. The voter turnout for West Pokot was 81.44. The voter turnout for Kachaliba was 81.44. I have highlighted in yellow. The voter turnout for Pokot South is 80.44. It is higher than Kapenguria. It is higher than Sigor. Comparatively, in fact, those voter turnouts were higher than the ones which the election were not proposed. That claim falls flat on the data that were provided to court. I will proceed. I will go to Rongai. The question the court asked is whether the postponed elections in Rongai led to suppression of voter. I have provided the data on Rongai. The voter turnout of Rongai was 61.41 for the presidential. It is higher than in Joro. It is higher than in Naivasha. And it's comparatively similar to the other similar constituencies. To the allegation that there was voter suppression in those places because of the election that was postponed, that allegation is untrue, falls flat on the data we have provided. To the other question, whether the postponed elections in the MCA ward for Nyaki West led to voter suppression, the voter turnout for Nyaki West was 64.32. If you look at North Imenti, it was even lower. It's comparatively similar to the other we have provided. To that allegation, that falls flat on the data than the comparative data we have provided. To the allegation that the MCA ward in Kwanjenga, that there was voter suppression because of that, the MCA ward in Kwanjenga, the voter turnout was 46.32, comparatively similar to Embakasi South, which is 49.62, comparatively similar to Imara Daima and also in Pipeline. To that allegation, when you look at the comparative data, it's not a matter of hypothesis, it is not borne out by the data. To the allegation that the postponed elections in Kakamega led to voter suppression in terms of the petitioner's votes being undercast, the allegation falls flat on the comparative data. We have provided the data for Vihiga, which is similar. Bungoma was a bit higher, but Vihiga is the same. So comparatively, when you look at those data points, that allegation falls flat. To the allegation that in Mombasa, there was a voter suppression because of the election that was run. I want to point out, even in 2017, the general voter turnout in Mombasa is generally very low. That data is available. It's always lower than the other constituencies. But comparatively, it is almost something that is comparable. To those, so I have answered. So to the question that the court put out on the comparative data, the answer is there was no voter separation in those places. Senior Counsel Kamau Karori has already explained on the reasons why those elections was not held. There was nothing premeditated about those elections, not holding those elections. Reasons have been given in the affidavits of the chairman Wafula Chebukati and Marjan Hussein Marjan. So to that allegation, we want to show the court the petitioners have a hypothesis. We have provided the data to the court to actually aid the court to come to a conclusion. The second question I want to answer that the court put out to us was whether there are unexplainable discrepancies between the votes cast for the presidential candidates and other elective posts. Indeed, if there was unexplainable discrepancies, is a grave issue, which we know. We will show through the data that we have provided to the court that the same is not true. In fact, we can account for each ballot. To just guide the court, refer to the affidavit of Moses Ledama Sunkuli, which is on record. We have provided the comparative analysis. In fact, what I did is we provided the 34C, the 37C, 38C, and 39C. Those are the forms for the governor, the senator, and the women rep. We tallied against the presidential. I want to refer the court to paragraph 36 of Moses Ledama's affidavit for the court to look at it. And if you do a tally, and we started with a tally for Senate, if you do a tally for the votes that were cast for the Senate, vis-a-vis, and that, Your Ladyship, that runs from page 13 of Ledama's affidavit up to page 15. And I just did the summary analysis, but there's a very big comparative table that I've put out there. If you do the analysis, you will come to the following conclusion. What is the voter difference between the senator and the presidential? 500 votes. The variance. And how do we account for those variants? So when you do the presidential like for like and the senator, you will get a difference of 22,801. You have to minus diaspora voters, which only vote for the presidential. You have to minus prisons, which only vote in the presidential elections. Okay? And then you have to look at stations which were affected and did not have any results for any of those elective posts. For example, in some of the stations, some few stations, some violence happened. Likely they did not report for Senate. When you do that analysis, you will get the differential is 500 votes. I have done an elaborate analysis also on the stray ballots. When we get to that, I will explain. So the differential between the Senate and the presidential is 500 votes. And that 500 votes, we can account for in stray ballots. I have attached the polling day diaries for Kibra and Makadara. I have done an analysis to actually check what is the stray ballot per constituency. And this tally is like for like. So to the question whether there was a discrepancy between the presidential and the Senate vote, the answer is an emphatic no. It is explainable by looking at what the information that we have provided. To the second question, whether there was a discrepancy between the women member of National Assembly for the women rep as compared to the presidential, I will tell the court to look at page 18, page 17 and 18 of Moses Ledama's affidavit. And our answer is there is no much difference. And the differences can be accounted for. The variance analysis we have provided. To the question whether there was a discrepancy between governor and presidential, we have also explained that there's no such variance. Petitioners have been talking of variance of 800,000, 900,000. There's no such variance. And in fact, the small variance that you will see for the women rep, which is 9,419, can be explained for by the stray ballots. A small analysis we did for the stray ballots, Your Ladyship, is that in Kebra constituency alone, we did a stray ballot analysis, and it's shown there. So to explain, and this is how we understood the court to mean the duty of the IEBC is to explain each ballot cast and track that ballot to see where it has gone. So once we do the analysis for the presidential and we remove the prison voters, once we remove the people who voted for diaspora, once we removed some of the small polling stations that did not report for any of those seats, you will see a small variance. So we thought the court will ask where that small variance is coming from. And so what I did is we went and we went to sample one of the constituencies in Nairobi. And in one of the constituencies, Kibra constituency, we got 405 stray ballots. So you can't account for the way it will work is it will take from any of those ballots small incremental numbers. So you will see a variance of 500 here, 200 here, but cumulatively it is not something that cannot be explained. And I have attached all the polling day diaries. In fact, if you look at the Form 34A, which was supplied to the court, some of the comments section will indicate that they found some stray ballot in the presidential ballot. But to the court, whether there is discrepancy between the senatorial, governor, and the women rep seats, as compared to the presidential, there is none. We have demonstrated that with data. And even when there's a small variance, we have shown the stray ballots that cumulatively over those 3 seats, that will be there. A question was, a submission was made by Learned Counsel, Ms. Julie Soweto, that there is 33 per polling station stray ballots in Kirinyaga. I will explain that. I don't know what numbers they are using. It's an old litigation strategy in numbers for shock and awe. I think what they are trying to, if you look at the numbers for Kirinyaga, there is no difference between presidential and the governor of 22,000. In fact, the variance is 900 votes, which can be explained for by the stray ballots. The number they have indicated for governor, I don't know where they have gotten it from, is not what is in our 37C, and we've indicated that in our submission and also in our presentation. So to the question that the court asked, that whether there are inexplainable discrepancies between the votes cast for presidential as against the governor, for presidential as against the women rep, for presidential as against the Senate, the same is not borne out by the data that we have provided to the court. Now I'll go to another issue which was made heavy weather of by learned counsels on the voter turnout. Justice Smoking Wanjala asked, how important is the voter turnout, valid votes, and to the actual declarations? Of course, it's an important issue. The only problem with it is that counsel are not understanding how we done using the kits. Pursuant to the Maina Kiai case, the court was very emphatic that elections must be conducted at the polling stations. And pursuant to that, voter turnout reporting is done per polling station. So how do we do it? When the polling station opens and Kenyans are voting, depending on the network access of the kit will be sending us information every 2 hours. They will giving us, the kit will be telling us 200 people has passed by this kit in this polling station, and that information will be collated until the end of polling day. So 2 things to note here. The first one is that the reporting is done per KIMS, per polling station of the reporting KIMS. So for example, on the 9th August 2022, when the polls closed, the IEBC gave a turnout figure of 56.1679%, which is the percentage turnout. That correlated to the total number of registered voters in those schemes, in those polling stations. The problem that the petitioners are having, they're saying these 56.1679% you announced must be of the total people in the register, which is 22,140,258, 120,258. We don't do that. We report per KIMS. So if 200 people reported in that KIM and the number of registered voters is 600, we say 200 of 600 voters. We add the next KIM, 300 people have reported, we say 300 over 600 voters. The next KIM, 400 KIMs have reported, 400 over 600. We keep on aggregating until we see how many KIMs have reported of those polling stations. Why do we do that? Because of two reasons. The first one is, which is in the affidavit of Hussein Marjan and the affidavit of the chairman, because of network issues in some places, far-flung places in Kenya, some of those KIMs will report late. Some of those KIMs will report much later. So if we did a number over the total number of registered voters, we will be giving a false turnout. So the turnout we give is based on the aggregated voters of the reporting station in that KIM. So if you took when we announced, the 56.1679% is based on the total registered voters in those stations who have reported in those KIMs, which was 21,481,642. Your Ladyship, you'll realize this is much lower than the total number of registered voters. And we'll keep on accumulating. KIMs will keep on reporting. 235 polling stations went manual. We will have to later on aggregate the 235 polling stations which went manual. Then we come with a total voter turnout. And if that is the reporting we do, two arguments that have been made in the petition of Omtata and in the petition of number 5 fall off. The first one is, their contention is that the chairman announced a turnout on 10th August 2022. That is the third line, Your Ladyship and members of the court, announced a turnout of 65.4%. What we have indicated is 64.6%. Your Ladyship, I will pause there to just inform the court that the chairman clarified that statement. The recording is in the affidavit of the chairman. And the actual clarification the chairman gave, he said that the total reporting polling stations, and if you hear his statement, it will give some clarification. We never say the total number of registered voters, because we will have that information when our manual count and everything has reported. We say total number of polling stations reporting. So in those schemes. So they're saying 64.6% must be of the total registered voters. That is their contention. That is their voter turnout. That is not the voter turnout of IEBC. The voter turnout as a percentage.
The team led by Senior Counsel Professor Gedu Muigai will have 15 minutes to respond to the questions that were 30 minutes to respond to the questions that were raised yesterday.
Good morning, Madam Chief Justice and the distinguished judges of this court. We are ready to respond to the questions that the court put to us at the end of the day yesterday. I have Mr. Mahat Somane, who the court has already found a fairly useful man in explaining numbers, and he will be responding on the numbers. But I have brought on board Mr. George Murugu, who has previously not been on the front bench, who is very, very well acquainted with the architecture of the electoral process, and both of them will be responding in the 30 minutes that you've given us. But there was a question directed to me personally by Lady Justice Jokindongo, and I will deal with that question at the very end. Mr. Brooke.
Good morning to all of us again, and Senior Counsel, just before your team starts, on the question of voter turnout, and as you respond, please bear in mind the following so that we know that you are answering our concern. In Forms 34A, some of them have the rejected ballot. That's what Mahat taught us yesterday. Added to the votes cast. So that the figures on 34A are not necessarily the figures in 34B and not in 34C. So tell us, as you answer the question in your own manner and style, on voter turnout, was it calculated on the numbers in 34A, B, or C? Senior Counsel, you understand our concern? Thank you very much.
Madam Chief Justice and President of the Supreme Court of Kenya, honorable and distinguished judges of this court, my name is George Murugu. I am here to answer questions that then the bench put to the Commission and to the Chairman. I will be as brief as possible, noting the little time that I have, and I hope that I'll be as useful to the bench as my colleague Mr. Mahat has been. Now, I will straight away start with the questions that were put to the first and second respondent by His Honorable Justice Ouko. And the first question was to do with the question of unutilized ballots and how they are accounted for. This is the way unutilized ballots are treated. At Regulation 69, which provides for the voting procedure, that is the Regulation 69 of the Election General Regulations, it provides that a voter will be issued with ballot papers for all elections in a multiple election. That is at Regulation 69.2. At 69.2a, he is expected to cast his votes in respect of all the elections. 69.3 makes it an offense for a person to knowingly fail to place his or her ballot paper issued to him inside a ballot box. But at Regulation 77E, an unmarked ballot is treated as rejected and is void and shall not be counted for purposes of declaring a result at the polling station. At Regulation 78.3, the presiding officer then is put under an obligation to record in Form 41 the head of rejection for each ballot, and for our purposes, Sub-Regulation 3D then addresses the question of unmarked ballots. Regulation 81B then provides that rejected ballots, such as the unmarked ballots, are sealed in a tamper-proof envelope and placed in the ballot box. That is how they are accounted for, Honorable Justice of the Supreme Court. The second question that I shall deal with, and this again it was posed by His Honorable Justice Mr. Ouko, was whether the appointment of the chairperson as returning officer was as an agent of the commission or as a national returning officer in his capacity as chairman. This is how I would wish to address this question. It is a direct one, and the answer lies in the Constitution. Article 138.10 places an obligation upon the chairperson of the commission to declare the result. So the gazettement was not for purposes of Article 138.3c, but specifically for Article 138.10 to fulfill that role, to take up that responsibility to account for that result that follows a presidential election. That is the specific purpose for that gazettement. But while I'm on this question, I would also want to pose another question. Would it then mean that if the Gazette notice was to fall away, would it then mean that the chairperson of the commission under Article 138(10) would not be in a position and suffer lack of constitutional authority to declare that result? My answer is no. In other words, the Gazette notice is purposely to tell Kenyans that the Constitution has rested these obligations upon this office to declare that result. Beyond that, it is superfluous. And I urge Madam Chief Justice and Honorable Justices of the Supreme Court that that particular gazettement should not be read to mean that the chairperson had gone rogue, that the chairperson had taken upon himself and arrogated unto himself a power that he did not have. It is the Constitution speaking. It is in fulfillment of a constitutional expectation and obligation under Article 138(10). If you allow me, my colleague Mr. Mahat Somane will address the other punctuated questions that don't feature in my presentation. I will address the questions posed by His Honorable Justice Mr. Lenola, and this question is to do with the understanding of the state of the law as far as Section 83 of the Elections Act is concerned. And this is our submission, that the law is in a state of flux. Why do I say this? In 2017, the statutory provision that then existed suffered an amendment through Election Law Amendment Act number 34 of 2017, effectively repealing the 2017 provision. Now, the new amendment similarly suffered terminal fate before the High Court in the Katiba Institute case. Therefore, one would be tempted to argue that as far as Section 83 is concerned, we have no law. But in my humble opinion, I would be more kind to the state of the law as it exists. It's in flux. Why do I say this? This court had had opportunity to address questions of what happens to a repealed statute when the replacing statute itself suffers the same fate, in the BBI case. And there was differing opinion, understandably so, because it's not a question that can be easily wrested. In my earlier days, if you ask me, I would say there's no power to animate the previous provision of law. It rested where it did at the point of being repealed or being declared unconstitutional. However, the Constitution provides a mechanism by which we can determine the validity or invalidity of an election beyond Section 83. That safety net is to be found in Articles 81 as read together with Article 86, and specifically for purposes of a presidential election, we must read it together with Article 138(3)(c), which then provides the qualitative test, the process that we then use to arrive at that result to be declared under Article 138(10). So that at Articles 138(3)(c), there is a process of verification and tallying of those results that then come from the polling station and from the constituency tallying centers. All right? Under Article 81, we are then to observe certain principles of the electoral system, failing which then an election can be rendered invalid. Article 86 addresses itself to the voting method and sets out principles that then must be observed in operationalizing that voting method. That is a qualitative test. The quantitative test then is found again under Article 81, or rather 86, sorry, 2, where counting is involved of votes cast, and Article 138(4), which then sets the criteria for declaration under Article 138(10). So then it is my humble submission, even as the state of the law remains in flux, there is a standard by which we can determine the validity or invalidity of an election, and that is my humble submission on that point. The second question, Madam Chief Justice and honorable members of the Supreme Court, directed at the first and second respondent by His Honorable Justice Lenaola, was why didn't the chairperson wait until the next day and try to reach consensus and address the 27 constituencies? It is important to point out at this juncture that the 27 constituencies had been tallied and had undergone the verification process and were ready for announcement by Professor Goulier. My lords and my ladies, I refer the Honorable Court to paragraph 35 of the affidavit of Professor Goulier filed in the main petition. And as to the circumstances why the chairperson opted to declare the results on the very day that he did, the explanation is to be found in paragraphs 86 and 111 of his affidavit. But if I may summarize, he made considerations concerning security of his staff, who at that particular point in time were suffering arrests, abductions, and injuries to officials, including commissioners. In his mind, it was prudent to conclude the exercise since Article 138(3)(c) had been fully satisfied. And there was a legitimate expectation that the results were to be declared on the 15th of August, as had been announced on that very morning. I'll quickly address the questions that were raised by Honorable Lady Justice Njoki. The term commission used in multiple senses. How do we know which sense is applied when? My quick response? It is a question of the context in which the term commission is used. Section 2.1 of the Iebc Act defines the commission to be the IEBC. Section 11A then breaks it down further to provide that there is that policy organ which is then constituted of the commissioners, including the chairperson, which then tasks itself with oversight, strategy, and policy, and the secretariat that then deals with administrative issues on a day-to-day and executing matters of policy that then the commission, or rather the membership of the policy organ directed. Therefore, in my humble submission, it's a question of context on how the term is used. What are the checks for this all-powerful chair? For instance, if he was to announce the wrong results or be incapacitated in such a manner that then he could not declare the result. The checks are to be found within the constitutional and statutory framework. Follows. Article 138 then speaks to the checks. Article 138(3)(c) speaks to a verification and tallying process that then engages the commission, the body corporate, so that there is no room for the chair to act as a lone ranger. And while I'm at this point, it is important to point out that in this particular case, Article 138(3)(c) was fully satisfied. My lady, my lords, a narrative has been created that certain commissioners were given roles akin to domestic services. Nothing can be further from the truth. We all saw it. We all saw the commissioners interacting with the results, interacting with the verification and tallying process. We all saw them announcing these results. We cannot unsee what we saw. But then, just to lay emphasis on this, I would wish to quickly refer the Honorable Court to paragraph 40 of the Chairperson's affidavit, Wafula Chebukati, paragraphs 8 and 9 of the affidavits of Professor Abdi Gulier, and paragraph 7 of Boya Molu, which speak to the truth of this issue. Quickly, my lords, on the last question, on the issue of agents and their roles. Agents play an important role in the electoral process. It's up to the parties and candidates to appoint them. But for purposes of Regulation 79(7) and 62(3), the absence of agents does not invalidate proceedings at the polling station. That would be the end of my presentation. Unless the court has any question for me, I would ask to resume my seat. Thank you, and invite Mr. Ma.
My Ladyship, CJ, Chief Justice of the Republic of Kenya, my ladyship, the Deputy Chief Justice and Associate Justice of Supreme Court. I will try to waltz and do very fast because I'm short for time. I will mention the judge who asked the question and I will give my answer precisely. Justice Ouko asked the question that 33,000 votes, there's a variance of 33,000 votes between governor and president. Nothing could be further from the truth. The variance between the presidential and the governor is 24,000 votes. The same can be accounted for stray ballots. He asked the question, what are the stray ballots all over the country? We have to look at all those ballot boxes to get what are the exact stray ballots in those. But I did a bit of analysis, and I've attached the analysis in Kibra and in Makadara. It is 2 per polling station. And the beauty about this is late last night, I also ran an analysis on the scrutiny report that we were given for the 18 polling stations, the report of the registrar. It exactly tallies. The stray ballots, even for that, it's actually 2 per polling stations, even if you looked at the scrutiny report. That gives you a figure of 92,000, the whole of the country, shared between the different ballot boxes. You cannot be able to know how the exact number of them, but that is the average. So if there's a variance of 10, 20,000, that's within, but anything way above that, you know, that cannot be accounted for by the 92,000 becomes very problematic. And I think I have attached that, and the court should look at that. So it's 2 per polling station, 92,000, which is accountable. So if there's a variance of 40,000, 50,000, then the court can question that. But anything within that range, that is within the normal range. The second question that Justice Ouko asked is, do you have any instances where voters walked into polling station and voted for presidential only? No, we don't have. The integrity of the ballot is very important. If someone comes into our polling station, we give him all the 6 ballot papers. He can do whatever we want with them, but he cannot go out with them. He can put it in the boxes, he can mark them, but he cannot. That's why we're able to account for either through the rejected or the stray ballots. So to the question that someone can vote for one candidate and leave the others, it's not true. It's actually, the regulations don't allow, it's a criminal offense for someone to get out with ballot papers or election material from the ballot box. The second question that has been asked is, Justice Ouko said the voter turnout, you say that there were 45,994 polling stations, out of which 46,299 polling stations were identified through KIMS. So only 235 were identified manually, out of which 6 did not have any election taking place because of violence, 229. I think the number you are interested is how many people voted manually, 86,889. 86,889. And the registered voters in those polling stations is 114,917. 114,917. 114,917. The interesting thing is we provided all the KIMS return. If you look at the affidavit of Michael Ouma, we provided all the KIMS returns. So you can check the KIMS returns as against how many people voted manually. Justice Ouko also asked a question. Justice Ouko asked the question that that is the number of the 86,889. Those are the people who voted manually. So the integrity of this process is very important because the other ones can be accounted for by the kits, right? The second question, Justice Ouko said, Omtata says 1,665,412 people curiously voted for when the polls closed. And I think this is a faulty analysis, and you really have to understand how the kit works, right? So when you open the polling station, the kit sends a message that we have opened the polling station, we are ready for action. People pass through it. It sends automatic returns. It pings to the nearest network, sends automatic returns over the period of time. If it's not able to get the network, it will keep that information for the next 2 hours. Yeah. So that is how the number changes. The polling will close, but some kins will be sending the people, how many people went through. And it's only when we know when all the KIMs have transmitted and we know how many people have voted manually that you can be able to look at that, to look at it. So polling ends at 5 p.m. There are areas that voting commences on 6 a.m. on the next day. Some places in Eldas, KIMs reported happens once the network, once it has network, and it I think it's a false analysis, because he says at 5 p.m. we should have known the whole turnout. It's not true. KIMS will keep on giving that information. Justice Lenora asked the information about whether the Form 34C is captured in JPEG and what happens to it. I humbly want to donate a KIMS kit to the court, a training one for the court to see itself. I have given a dummy form, a training Form 34A. I have also given the password. The courts can take the picture and actually see what happens. The kit takes the image, and it's on the image that actually the conversion happens on PDF. We don't do any JPEG, and there's a reason for that. In fact, if you look at it, when you are taking the image, it will ask you for the QR code, whether it is proper. It will ask you for the gray scaling, and you will see how we do it. And we do for JPEG, because all your phones take JPEG. We want to differentiate our image from the ubiquitous images of JPEG. So that one I want to, through the registrar, I want to donate to the court to see it, a live demo. Justice Wanjala asked the issue of turnout of 65.4. I want to tell this court, at paragraph 30 of the affidavit of the chairman, that clarification was sought and it was given. And the chairman, and there is a video to it actually, the chairman clarified, and he said the turnout is not 65.4, it is 64.6. In fact, you will see Martin Nyaga rushing to the chairman, telling him, the person who was in charge of the cumulative of the turnout, telling him, no, that is erroneous. So the number is 64.6 at the point where he made. Is turnout really important in the declaration? I want to tell this court, there is this fascination by the petitioners on turnout. We don't use turnout to determine the presidential election. I think that is the base to start on. The reason why we give turnout is a measure of transparency and integrity, to know how many people pass through the kit. And the problem with it is a lot of people don't understand how these kits work. If you look at the numbers I gave on that screen, you will see, in fact, if you look at 2045 hours, 63.6 and 64.6, you will see that the total registered voters on 9th August 2045 is 21 million, under the KIMS 589,961. On 10th August is 21,926,565. If you deduct those numbers and you compare to the people who are actually identified by the kits, actually the people who are identified by the kits is more than this number. And a lot of people will say, oh, why do we have more people who are registered in those stations than people voted? It happens. And because the relationship between the people who are identified in the kit and those total number of voters in those polling stations is not a linear relationship in this sense. So 9th August 2045, a kit will report 10 people. So we'll say 10 people have been identified in those kits, but the number of registered voters is 700. We will add in the total number of registered voters. You reached 10th August 240. That kit has already given its maximum registered voters in the original reporting. But people will keep on passing it. When another 20 people pass through, the kit will report 20 people have passed me through. So we will say the voters identified under the KIMS has increased. But we don't increase the registered voters in those polling stations because it is already reported. So the relationship is not one-to-one. And you have to understand, and this is the confusion that is coming, we have to understand, the only way you will know the total registered voters is when all the KIMS have reported. So when all the KIMS had reported, because this is a snapshot of that information in time, when all the KIMS had reported, the voter turnout was 64.7103. So what was remaining that time? Only the manual voters. How many? 86,899. So it's good to understand that, because if someone just looked at this information, you will come with all manner of confusion. So the kit will report, once one voter passed through the kit, we say one voter identified, but the column of registered in that policy we put 700. But the voters will keep on going through the kit. So as people go through the kit, we'll keep on increasing the voters identified in that kit, but the number of registered voters will remain constant. The issue of the Venezuelans, they were involved in deployment of infrastructure and the servers platform. They did not have any access to the RTS. Look at the affidavit of Michael Ouma. Look at the affidavit of Hilda Kavongo. It actually shows the kind of rights they had. There was no unauthorized access, and in fact, the scrutiny report will bear that out. Did the postponement of elections in those counties only affect presidential voter turnout? I have indicated that is a hypothesis that has been laid out before the court. It is not borne out by the data. In fact, the voter turnout was comparatively the same. If there is no agent, Justice Muilu asked, if there is no agent, what happens? The integrity, the processes that we have in terms of the KIM's return, in terms of the portal, even if there is no agent, we can actually confirm what happened. So it's not the role of even if someone said I did not have an agent, but my votes have been tampered with, we can be able to find out. Demonstrate, I have, go to the last page. In the 40 seconds, Madam CJ, I can demonstrate that. If you look at that form, that is a form, the agent copy. If you look at the second last one, where it starts from demonstrate, 34A, please. So look at that form. So side by side, it's the agent copy and what is in the portal. We have marked all the places that what is wrong with that form. What is wrong with that form? If you look at the elevation of the camera, same. If you look at the Iebc logo in the background, both images, same. If you look at the exact paper fold in the bottom left corner of both images, same. The own editing, that's the top left is dark. The agent copy is in JPEG. The form is uploaded on our form is uploaded on the portal 10th of August 2022 at 2 days later. And we have put that in our affidavit, actually. You can check all the edits.
Sorry, Counsel, you are not being recorded, but we suggest that you take the next 2 minutes and finish. Please put the machine back. You're about the end, right?
Yes, I am to the question that Madam Chief Justice and the President of the Court asked. I gave two examples. If you can just go back, I think I'll start with the first one. The 185, yeah. If you can go back.
We'll give you 5 minutes, see what you can do with it.
Yes, yeah. Thank you so much, Madam CJ. So what we did is we just took the form they provided us and we juxtaposed as against what we have. And we've marked all the places what is wrong with that form. And what is wrong with that form? If you look at the QR code, up on the left, on the right, and also on the left, the QR code, it's cropped similarly in both pictures. The Iebc logo underneath the document coincides with what was the pressing officer. It's actually an impossibility. I've given you a form to take a picture, and what you are producing me is actually underneath the logo of the document, the Iebc logo that the presiding officer was using. So I've given you your form, you're taking your picture for your agent, and you're using the same that the Iebc PO was using. Both photos are taken from the same elevation. I believe the court has ICT experts, and in fact, you don't need an expert to look at this. Look, the margins cropping are the same, which is really amazing. Look at the margin cropping for both of them. And there's no any other conclusion. What people were doing is that you will download, because there's no way you can be able to get our forms are different, and this form has gone through many processes from the polling station, county tallying, constituency tallying center. So the forms are ubiquitously available. They are available everywhere. The only way you can be able to do anything about it is you have to download our form and try to do tamper with it, what the agents in this case were doing. If you can go to the second one. This is the one I was describing. In fact, this one has, it even has the timestamp of their form, JPEG. We don't do JPEG. This form was relayed to them 2 days later. The elevation of the camera.
Certainly, this is not a light issue. Yesterday, there was extensive submission as to whether this court is handicapped in terms of dealing with some of these things. Now, as the IEBC, on the one hand, tries to improve the system based on the law and the guidance from this court, I think there's also a responsibility that should attach or follow where we have very deliberate attempts at misleading the court. If we look at, for instance, the logs that have been attached by John Mark Gidongo, if it turns out to be a forgery, does it not disclose an offense? It is not in my province to make that determination, but where I see it, it bothers me because as we go into elections this year, in 2027, we need to then sanitize some of these things that we do. And one of the ways of sanitizing them is by holding people to account, so that if you present evidence that is obviously not true or that is falsified, then you must stop to ask yourself whether there would be a consequence or not. That is the only way through which even this court would be able to sit, to be able to determine or preside over any of those matters that are presented with ease. I need to add that at the Bomas, which is the National Tallying Center, when the returning officers got to Bomas, what happened? Now, in the flow of Bomas, these returning officers would come with their original Form 34As, hand them to the national returning officer for purposes of a presidential election. After that, they would be subjected to an ICT team, and that ICT team was not sitting in isolation. They sat with the agents of the parties, they sat with observers, and what they were doing was to again confirm those security features we had spoken about. After that, they went into the detail around the numbers, comparing what they had in the Form 34As that were in the portal and the Form 34As that were then presented, the physical hard copies. From the direction and guidance of this court in 2017, Raila Odinga, what the commission was to do was to record those errors. I confirm, my ladies and my lords, that the commission did exactly that. The error report has been availed to this court, but of significance is that as they were preparing that error report, a copy of that error report was also availed to the agents of all the parties. This is important in the architecture of our elections. It is important because, as opposed to asking the court to now go through scrutiny, it will be a question of saying, wait a minute, in the error report, there's a difference between the results that came from member primary school, which I have either in my carbon copy from my agent, or that was presented by the returning officer, and what we are now seeing in the portal. That is the only way through which somebody could make an allegation that would stand the test of time. If you have that, then certainly, if you apply yourself to understand the architecture of our electoral platform, then there is really no need to go into scrutiny, because that report is scrutiny by itself. In fact, it was a forensic audit. They had their watermark readers, they had their UV light readers, and these are things that are all contained in the affidavits of these three individuals that I've spoken about. When you take time, you look at that, and it is then our submission that to the extent that there is an allegation that there were interferences or that there were differences between the Form 34As in the portal and the Form 34As physically presented by those returning officers, there was none, and this is verifiable. Indeed, none has been presented before you. The last issue I'm to deal with is whether there was a difference between Form 34As uploaded on the Iebc. Sorry, I think I've gotten into that point as well. And so, there was a question that was raised about Form 34C and the concern about the multiple entries. Submission was made by counsel that the Form 34C is supposed to be generated once. Again, that sort of submission would only come from a false, if not limited, understanding of the process. I say that because as the verification and retallying of the Form 34As were going on at the National Tallying Center, whenever they completed the verification and retallying of a constituency, they would then upload it onto the Form 34C after the completion of the verification. That then meant that that process had to be an incremental process. That is why when somebody says that there is a gentleman called so-and-so who accessed the server or the rear end of the result transmission network 1,000 times, it simply speaks to the fact that they had to make entries. It should not be lost that we were using, according to the jurisprudence in Maina Kiai, results from the polling station, which is the original Form 34A. Now, if we look at the number of the polling stations, it speaks to about 46,000 and a few hundreds. It then meant that a corresponding number of entries, entries had to be made on that Form 34C. And that, because I'd said it is supposed to be done incrementally, I would want to refer for clarity again to the affidavit of Commissioner Justice Nyang'aya. At paragraph 51 of the affidavit of Commissioner Justice Nyang'aya, he says, or he acknowledges, that indeed it would be inaccurate, impractical to expect the 7 commissioners to be the ones to do all these specific assignments that the commission is supposed to be doing. Similarly, and by parity of thought, when the law says that the commission shall, for purposes of this, generate that Form 34C, the law does not contemplate that the chairperson of a commission will sit with a laptop and make 46,000 plus entries by himself. This is what my learned senior counsel Kamau Karori was speaking to. This is what is contemplated under Section 11 and 11A of the Iebc Act. And so, if we then tie this to the submission that he had earlier on made, that if we read under Article 138(3)(c), the Independent Electoral Commission to mean the entire institution, then we would not run into the problems that we are running into. Because as we saw, and as will be demonstrated in, by our subsequent speakers, that exactly is what happened. The entire bureaucracy or the entire institution of IBC participated in that process. As I conclude, I want to make a submission that when we make these allegations in our election petitions, perhaps we need to also ask ourselves if we have done that which the law contemplates of us. And that if the law gives you an opportunity to choose your agent for purposes of verifying or speaking to you in relation to the processes in the election, if you fail to present an agent, would it be appropriate to then come and burden the subsequent processes through applications such as what we're seeing for scrutiny? Because the law contemplates that that agent should be able to point you to the fact there's a problem in a particular primary school. Go there. Don't ask for the entire of a constituency. Don't ask for the entire of a county. And I think that has been the jurisprudence that has been developed. It then follows that we must sanctify the place of agents in our elections. And because agents are like our spouses, you choose your own. You choose the one you trust. If you get, nobody imposes an agent on you. If you choose one you don't trust, then really you can't blame anyone. If you choose one who does not understand why you assigned them that responsibility, again, you cannot possibly blame anyone. So, as I seek to take my seat, we ask my ladies and my lords that in the usual strong manner in which you've spoken in relation to these issues, and following the very lengthy submissions that we had yesterday, we also rely on you to help us clean this electoral system, so that as the commission does its part, on the other hand, the public and every other person must also do their part. I am most obliged, and thank you for according me this opportunity.
Court, may it be noted that the question of the voter turnout in this election is a moving target. It is a moving target depending on who's speaking and in what circumstances. If you look at the replying affidavit of the chairman, paragraph 30, as of 9th of August at 5 p.m., he says the turnout was 64.6%. That is an affidavit he's swearing way after the fact. The director of elections of that same date, at that same time, in paragraph 21, that is Moses Sunkuli, says it was 56.17 at that same time, looking at the same Kimskit. It will be noted by this honorable court that at various times, the Iebc gives different figures. At one time, it uses the figure of 65.4%. At another time, it uses the figure of 64.6%, on which Iebc proceeds is wrong. And that the reason for this moving target is so as to manipulate the question of voter turnout, to come to a conclusion that the 9th respondent met the constitutional threshold when they didn't. I wish to submit, Your Ladyship, my lords, that Article 138 is very clear, and the total number of registered voters must be specified, and that is the denominator. The Iebc did publish a gazette notice that confirms the exact number of registered voters and gives it as 22,120,458. In this court, using what they say is the turnout per the Kimskit, the figure they are seeking to use is 22,005,541. We wish to submit, Your Ladyship, my lords, that that premise is problematic. The common denominator to be used is the voter turnout as published in the Gazette, not the voter turnout as per the Kimskit, which ends up with a moving target. We wish to submit, Your Ladyship, my lords, that not only is it true that the target is moving, if you look at all the permutations, and this is in the supplementary affidavit of Dr. Edgar Otumba, if you take any of the scenarios and you use any of them, and we will submit, we have submitted this for ease of reference, because Dr. Otumba covers is between paragraph 5 and paragraph 30, and puts all those graphs. By whichever permutation, none of the candidates then achieves 50% plus 1. Whether you use, remove rejected votes, you add rejected votes, whatever permutation, and there are 7. We wish to submit, Your Ladyship, my lords, that you then need to come to the conclusion that even though they try to take time to tamper with the voter turnout, they do not achieve that target. The last point on that. Why is it wrong to use the vote turnout as per the so-called Kimskit? Other than the fact that it's unlawful, it is also illogical. We have 46,229 polling stations. If you are to rely on the Kimskit, and all 42,298 Kimskits failed, and only one in one polling station functioned, then it means that if the 700 voters in that polling station voted, the Iebc will be telling us that the voter turnout is 100%. That would be the logical consequence of that narration. That cannot be. The voter turnout cannot be something that depends on the interpretation of the IEBC at its convenience. It must be the denominator as a percentage of the total registered voters. My second point, my lords, my lady, and I do not want to go too much into this, the question of the infrastructure, what the IEBC called the impregnable military style infrastructure. I think it's been demonstrated that it was certainly not at a military grade. It might be important to note, your ladyship, my lady, that the one question they failed to answer was why was there stoppage of the streaming of the results at Bomas? They have not answered that because that military grade infrastructure was obviously compromised. My lord, my lady, we say that it is bad to have a sovereign institution that is captured by the state, but it is worse to have one that is captured by foreigners. We submit that is the position in this one. Your ladyship, my lord, the question here, and that's my third and last point, is really very simple. And it's a question that draws directly from Article 138(3)(c) of the Constitution. It is very clear, it is mandatory, that once results are received, the IEBC, not the chair, shall tally and shall verify, then shall declare results. If the IEBC as an institution has not tallied, has not verified, then there are no results to be declared. We wish to submit that at the end of this analysis, it is not a question of whether the chair is a hero or otherwise. It is a question of whether the chair did what was expected of them. It is not enough to say that there are certain regulations by the first respondent which they themselves made and now they wish to rely on to breach the express provisions of the Constitution. We wish to submit, your ladyship, that in accordance with Article 141, only if there's a result properly declared can you even move to challenge it. In this case, none was done. Your ladyship, what the chair is inviting you to do is unconstitutional. This bench comprises eminent persons who are involved in the process of making the Constitution, as some of us on this other side. There's a good reason why we've created constitutional commissions and independent offices. If it was intended to create the chair as what was previously called the supervisor of election, there'd have been an independent office, like the Auditor General, Controller of Budget, like the DPP. But now the chair is inviting you to find that his is some sort of imperial chairmanship or chairpersonship in defiance of the Constitution. We wish to invite you not to accept that invitation to amend the Constitution belatedly. My lady, my lords, at the end of the day, the only question will be, did the chair act in accordance with the Constitution? Is it fair to invite you to find that the other commissioners do not matter? The chair of IEBC is a first among equals, just like in this court. There are 7, just like the judges of this court. But the fact, your ladyship, you are the Chief Justice and you are the president of this court. Yet the Constitution would not allow you to exercise veto powers over the other colleagues. Why would the chair believe that he can have such powers over the other colleagues? Ultimately, my lords, your lady, it is the decision of the majority that must be the decision of the court. And similarly to the IEBC, as we are here today, the decision of the IEBC is that the match that was being played was stopped by the referee. If it was in court, it would be a mistrial. By their own admission, they have said that things happened which should not have happened, and therefore it was not complete. My lords, my lady, in 2017, this court made history by nullifying the first presidential election in this continent, and I think only the second known to me in the world. In this year, it is the Iebc that is making history. It is the first electoral body to concede that they did wrong. I want to submit, my ladies, my lords, that you cannot override that decision by Iebc itself because it's made by the majority. I wish to stop there for now. Thank you, my lord.
I will be addressing the first, second, and third issue in the list of issues that were framed by the court. My ladies and my lords, I will, in addressing you on those issues, rely on the affidavits of Michael Ouma, dated the 26th of August 2022, and rely on the affidavit of one Martin Wachira Nyaga, dated the 27th of August 2022, and the affidavit of Hilda Kavonga, sworn on the 27th of July 2022. So coming to the first issue, which is whether the technology deployed by the Iebc for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results, I will take a few moments to demonstrate how the technology that was deployed in the just concluded elections then met those constitutional imperatives. As a starting point, my ladies and my lords, we may want to ask ourselves, what exactly is this technology that we are talking about? And in answering that question, perhaps a bit of context would be of help. In the period just before the 2007 elections, when we still were dealing with the defunct Electoral Commission of Kenya, the legislative provision then, the equivalent to our Section 44, was worded in very loose, perhaps permissive terms. It was that to the effect that the Electoral Commission shall use technology where applicable or as may be appropriate. After the 2007 elections, we had the Kriegler recommendations, which then, one of which was that we must employ, or we should employ, the use of technology in our elections. When we got to the 2013 general elections, there was a good attempt at using technology, but the various forms of technology that were used were not were in different platforms, so that there was a different platform for purposes of registration, a different platform for purposes of identification, and a different platform for purposes of transmission. That did not work very well, perhaps because of the inefficiency attendant to the system then. Came the amendments in 2011 to Section 44, which required then that the technology to be employed was one to be integrated, meaning that in that one solution, we had the solution, we had the option for voter registration, which is biometrics. The second was electronic identification of voters and electronic transmission of results. Now, the question that we have before you today is whether, as conceptualized, that solution then meets the constitutional imperatives under Article 86 of integrity, verifiability, security, transparency, and accuracy. I will take a moment to just demonstrate how each of these would have been achieved. But when you retire, though, to consider the decision, I would invite your attention to specifically the affidavit of Michael Lohuma, who sets out in a very granular sense how these imperatives were met. I then would want to talk, that is specifically paragraph 39 to 49 of the affidavit of Michael Ouma. I then would want to talk a bit to the process entailed in those three items. And I'm sure we are most of us are familiar, those of us who have participated in elections are familiar with that process. That once the voting has been done and the polling station has been converted for, to the evening now for purposes of tallying and counting of results, we start by the counting in a very transparent manner. The presiding officers count each and every ballot, and I'm sure we've witnessed this, showing a vote for Gumbo, a vote for so-and-so, and a vote for so-and-so. Now, at the end of that process, they are then tabulated to give us Form 34A. How then is technology infused in Form 34A? Form 34A has internally identified security features. There are 8 in number. We have watermarks, we have UV potentials, we have microtext, amongst other security features. What is the significance of this? It is so that when somebody looks at the Form 34A, the original, it cannot then be confused for any other form, and that whatever it is that happened at the polling station remains an authentic representation of the will of the people. What then happens is that after that form has been tabulated, it is captured with a KIMS device. One copy is sent to the National Tallying Center. Another collects all the, takes the Form 34A for purposes of the collation to the constituency tallying center. That, again, is to achieve the constitutional imperative of verification. When we get to the constituency tallying center, the returning officer has a back-end access to be able to load their Form 34B and transmit it to the National Tallying Center. Once that is done, they will then go with their Form 34A, together with their Bs, to the National Tallying Center for purposes of the verification and tallying at the National Tallying Center. Again, it is important to note that by the time the returning officer gets to the National Tallying Center, we have the image that is already in the portal. When they get there with their original form, an opportunity is then presented again for verification, for confirmation of accuracy, and more importantly, that in this election, because of the decision that was rendered by this court in the Raila Odinga decision in 2017, the commission, in reconceptualizing or reconfiguring its electoral architecture, gave a public portal for people to be able to also follow, thereby meeting the constitutional imperative of transparency. It then meant that if I'd gotten my results from my village, my primary school where I vote, I would be able to follow those results all the way to Nairobi and take account and follow if at all there is anything that would have happened or changed. Then I must be the first person to be able to raise that concern. It should also not be lost that in that polling station, we have our agents, we have our observers. Again, to add to the fact of verifiability. So that then is the architecture of what our election pathway looks like. That said, it then must follow that at the polling station, if I am a candidate, I certainly must have interest in the outcome in that particular polling station. Because a copy of the results from the polling station would be given to me, I then should be able to communicate with my team, perhaps my national agent for a particular candidate, a particular party, to be able to demonstrate that what we got in member primary school and what has been transmitted to the National Tallying Center is one and the same. And that in the event that there's a discrepancy, it does not take magic to be able to point out that. Now, as to whether this technology was successful, Michael Ouma deposed in his affidavit that 46,201 KIMS kits deployed throughout the Republic worked out of the 46,229. It then leaves us just with about 200 KIMS kits, which did not work at the opening or start of election on that particular day. I asked myself, if out of 46,000 KIMS kits, only 200 do not work, would I say I've failed? Even in our educational system, an A does not connote 100%. It starts somewhere from 88%, going all the way to 100%. The mathematical representation of this gives us more than 99% success rate. In our view, that then achieved the constitutional imperatives that are contemplated under Article 86. Again, for purposes of confirming whether that system is secure, I invite you, my ladies and my lords, to look at paragraphs 51 to 63 of the affidavit of Michael Ouma. Again, just to mention a few items in relation to that, that KIMS gadget works in specific ways. It is first locked to a specific polling station, meaning you can then not use it once you've locked it to the events of that day to transmit results from a different station for purposes of that election. That the entire network through which the results are transmitted are secured or double layered with firewalls, meaning there's the first firewall and the second firewall for purposes of securing that transmission. Very significant again to mention that at the point at which that image is to be transferred, it is encrypted. So as it is transmitted, it is not in the form of what we would imagine the image of Form 34A. If I was to use an example, if it was to be a water pipe and it is to be encrypted. It means if you broke into that water pipe, because we all know that the chemical formula of water is H2O, you'll get your hydrogen on one side, you'll get your oxygen on one side. It then means you'd not be able to make sense of that water that you're looking for. Again, we must be able to relate this with other factors. In the KIMS kit, we have certain information that is resident, close of business in any polling day. One of them is the question as to the voter turnout of a day. It means for somebody to intercept that system, they must have information in relation to the voter turnout of that day. It may not be practical for somebody to say that they have the capacity to know the voter turnout throughout the country at the second at which they want to intercept a particular form transmitted. Again, if we exceed the number of people who voted, then again, from an accountability perspective, it would be very easy to point out to say, because of the fact of this interference, you've exceeded the numbers of what was captured in your report. To give further comfort, this transmission is done over a virtual private network, which is provided by the mobile network operators, who themselves also secure that environment to ensure that there is no intrusion or interference coming from any quarter into the system. For a good, perhaps, mental understanding of what this means, or how this was applied, Michael Ouma in his affidavit says that there were more than 380 million hits on trying to, just to access the public portal. And that according to him, none of the systems even blinked. That is how secure that environment is. Now, the other question that somebody would want to look at in relation to Article 86 is the compliance with the provisions, statutory provisions in relation to procurement and all those. Again, I invite you, my ladies and my lords, to look at paragraph 64 to 71 of the affidavit of Michael Ouma. He then ends at saying that close of business, more than 14,239,000 people were successfully identified through that system. He describes it, to use his words, as a military-grade system. That is how comfortable he is with that, with the security features of that system. I come to the second question, which is whether there was interference with uploading and transmission of Forms 34A from the polling stations to the Iebc public portal. The emphatic answer is no. I have given a general description of the infrastructure that was laid out. I will take a few moments to demonstrate that it wasn't possible to into the system. Then it would have been noticeable to again speak to the fact of verifiability, and that one would be able to pick that with pinpoint precision because of the manner in which the system works. For purposes of a clear understanding, it is purely because of that verifiability that we are able to hear our colleagues appearing on this other side for the petitioners saying that they saw a gentleman called so-and-so who accessed the system. So-and-so accessed the system because of verifiability. It means that those who were able to access the system must have been people who were then authenticated to access the system, because certainly you must get some human intervention if the system is to work. To this extent, we'll then invite you to look at the affidavit of Hilda Kavonga. Hilda Kavonga is the manager, security and business continuity. Again, Hilda confirms emphatically that the system was not breached. She speaks at paragraph 7 in good detail about how robust that system was. I invite you, my ladies and my lords, to look at the structure of that infrastructure. and just appreciate for yourselves how then it was secure for purposes of protecting the will of Kenyans. At paragraph 12, she even goes on to give security assurance through certification from the National Institute of Standards and Technology. Now, we look at this in relation to the allegations that have been made. There is an allegation about staging. Learned counsel, senior counsel, Philip Murgor, spoke about the man in the middle. The indication or the allegation appears to be that somebody intercepted the system or broke into this system, downloaded this form, altered this form, uploaded it again, and sent it or transmitted it to the National Tallying Center. Like I said, when eventually we have an opportunity to look at the details that we have submitted, including the KIMS returns, it will be apparent that there was no such intrusion. But assuming for one moment that we want to interrogate this fact of staging, we then would want to ask ourselves, at what point in time did this happen? Because according to the infrastructure that is laid out by the Iebc, once a form is transmitted from the polling station and it gets to the public portal, it also has certain inbuilt security components. It has a digital signature. That digital signature marks an indication as to the exact time when that form was transmitted. If there's intervention, then certainly there must be a lag between the time when that form was transmitted and the time the form got to the National Tallying Center. It is our submission that nothing has been presented before this court to even come close to making that suggestion. Again, as part of the security that is in the portal, each of the forms that get there are serialized. And the serialization is tied to the polling station. It is tied to the date, to the time, up to the second when that form was received. It then, as an additional property, gives you a tab to be able to confirm or verify whether there's been any alteration on the form from the time it was transmitted. One would then very easily pick up that as a concern to say, we refer you to, again using my primary school in Member Primary School, that the form 34A that was sent from Member Primary School was intercepted, manipulated at this point in time. That is a report that the portal would be able to generate. Again, not a single piece of evidence has been given to come close to suggesting this. I've pondered since the submissions and presentations yesterday from our learned friends appearing for the petitioners as to what really this evidence is. I have, in the course of struggling to look for this evidence, come across three possible areas they'll be talking about. In the affidavit of one John Mark Gidongo, they make reference to a form 34A from Baringo County, Tiati constituency. They then say that that is an example of a form that was intercepted. Michael Ouma, in his affidavit, confirms that in fact the form that was uploaded or that was attached in the affidavit of John Mark Gidongo is not a form that arose from the process that, that they allude or allege it arose from. That according to him, this form was downloaded. Somebody tried to interfere with the details on it and attached it to an affidavit. Now that, if you asked me, is perhaps the silliest way of doing any of these things, because If somebody asked you whether that form was authentic, you only need to look at the public portal. You then need to verify it with the Form 34A that was presented. My ladies and my lords, as a statutory requirement, we delivered all the Form 34As to this court. We have a copy. The entire public has copies of each and every of those documents. Our team went through those documents, and in relation to that specific Form 34A, to say the least, it's a forgery. The second attempt, again by John Githongo, in his affidavit, to try and present some form of evidence is in the form of logs, which were alleged to have been gotten somewhere. It says Karen, with these 56 mysterious people, and this, I think, is what senior counsel Professor Githu Muigai was talking about, hearsay on the back of hearsay. I was told that I had. Really, is that the sort of evidence that we want to present before this court? We took time, that is, the ICT team took time to study the logs that were presented. My ladies and my lords, I'm sure you have appropriate infrastructure to be able to make a determination on your own as to what these logs entail. From the analysis that were conducted, and this is again contained in the affidavit of Martin Nyaga, these forms, these logs, arose potentially or were picked potentially from the 2017 general elections. Martin Nyaga, in his affidavit, identifies 9 obvious inconsistencies. I want to allude to just 2 or 3 of them. That, and that is in paragraph 13 of the affidavit of Martin Nyaga. If you look at the manner in which those forms, those logs are structured, they serialized, in 2017, the Iebc serialized its logs using the names of the constituencies. In that particular log, you'll find a name Changamwe. This time round, they did not use the names of the constituencies. They used the serial numbers. So that is a first inconsistency. Looking at those logs again, you see the name of one Asenge running an IEBC email account. Asenge was one of the returning officers of the IEBC in Changamwe in 2017. One is then left to wonder, at what point do we get to even forging documents, forging logs, to be able to demonstrate our case? Perhaps I will get to that a little later. Enters the third piece of evidence, which was supposed to now clean what was presented by John Mark Githongo, the affidavit by one Commissioner Justice Nyang'aya. Commissioner Justice Nyang'aya attaches logs to his affidavit. He then emphatically indicates that those logs go into confirming that specific named people accessed the system and that they then interfered with the results. He names 3 officers from the IEBC. Their details are in the affidavits. My ladies and my lords, again, we took time to run through those logs. The logs that were presented in the affidavit of Justice Nyang'aya, according to the information from the ICT team, and this is to be found in the affidavit of Hilda Kevongo, one, do not speak anything towards identifying any of those names that are contained in the affidavit of Commissioner Justice Nyang'aya. In fact, according to Hilda Kevongo, those logs speak to the ordinary applications that run the systems in IEBC on a day-to-day basis. If you read through them, because they're written in English, you'll find indications like daily update completed, news downloads for the day completed. At no point throughout the 7 or 8 pages, which is supposed to be a representation of the logs, does any of the names of these individuals feature. One then is left to wonder why such an inconsistency had to come in the manner in which it came. We have had allegations about certain named individuals. There's been an allegation about one Abdidahir Malim. My ladies, my lords, Abdidahir Malim was one of the returning officers, duly gazetted for purposes of this election. Like I earlier said, he then had access limited to the singular purpose of transmitting the Form 34B in relation to the area he was presiding over. That, therefore, is an authorized person. And indeed, Hilda goes on in her affidavit to confirm that all those other people who were mentioned were people who were duly authorized. There is the heavy weather that was made about the Venezuelans. A specific name has been dropped of one Gaidino Omar. My ladies and my lords, the contract between Smartmatic and Iebc was for the supply and maintenance of the infrastructure that they had. It then meant that they had to bring their personnel to manage or just monitor the smooth running of that system. Of significance is that Hilda, in her affidavit, then goes on to say that before the election, these people were all logged out of the system, and that on the date of the election, none of these people was in the system, even for purposes of that maintenance. My ladies and my lords, it would make a lot of sense if somebody said that so and so got into the system and they interfered with the system in this manner. It is not enough for somebody to say Gumbo was found in the system, because what matters here is the allegation around manipulation and alteration of the results. Now, if we do not get into this space, what exactly are we talking about? I would want to again equate this to a situation where in your house, you decide to assign a plumber to do for you some work. When the plumber comes to do the work, then you raise an alarm and say, oh wait, there's a plumber in my house. How is a plumber to do the work that he's supposed to be doing in the house? Certainly, it does not make much sense. If you expect the plumber to fix the plumbing problem, then certainly you must give him access to the plumbing problem that you have. Now, I have looked at, and we've tried perusing through all these documents. There is not a single form that has been presented which appears to suggest, even in the lightest of ways, that there was any interference. And again, just relating this to the architecture of our elections, if at all there was any such interference, it would have been an interference that goes into the numbers. Now, because we have not seen that, is this the case then, therefore, why numbers has become a very dicey and perhaps an area where everybody would want to avoid or run away from? In the petition, I suppose the first and most important thing is you must demonstrate that you had specific numbers. Even if there's to be this set of numbers and the other set of numbers, it can't be a contest between the man who was said to be the man in the middle and numbers. If that man was in the middle for sure and he had a job to do, then that is a man who slept on his job. Because we are not shown anything that he perhaps could have done while in the space that he is alleged to have done anything that would have interfered with the will of the people. Hilda continues to wonder in her affidavit as to why their boss, who is a commissioner, would expose them to that extent that they mention names of people who are employees and staff of the institution doing their legitimate work. Then you cast aspersion without basis that they were engaged in a criminal enterprise. My ladies and my lords, it might sound like a light issue, but we must have seen it in social media, in mainstream media, that these people, some of whom ran this election, have had to go into keeping house. They've had to go into hiding because people read these sort of things and they imagine that this is the gospel truth. Certainly, this is not a light issue. Yesterday, there was extensive submission as to whether this court is handicapped in terms of dealing with some of these things. Now, as the Iebc, on the one hand, tries to improve the system based on the law and the guidance from this court, I think there's also a responsibility that should attach or follow where we have very deliberate attempts at misleading the court. If we look at, for instance, the logs that have been attached by John Mark Gidongo, if it turns out to be a forgery, does it not disclose an offense? It is not in my province to make that determination, but where I see it, it bothers me because as we go into elections this year, in 2027, we need to then sanitize some of these things that we do. And one of the ways of sanitizing them is by holding people to account, so that if you present evidence that is obviously not true or that is falsified, then you must stop to ask yourself whether there would be a consequence or not. That is the only way through which even this court would be able to sit, to be able to determine or preside over any of those matters that are presented with ease. I need to add that at the Bomas, which is the National Tallying Center, when the returning officers got to Bomas, what happened? Now, in the floor of Bomas, these returning officers would come with their original Form 34As, hand them to the national returning officer for purposes of a presidential election. After that, they would be subjected to an ICT team, and that ICT team was not sitting in isolation. They sat with the agents of the parties, they sat with observers, and what they were doing was to again confirm those security features we had spoken about. After that, they went into the detail around the numbers, comparing what they had in the Form 34As that were in the portal and the Form 34As that were then presented, the physical hard copies. From the direction and guidance of this court in 2017, Raila Odinga, what the commission was to do was to record those errors. I confirm, my ladies and my lords, that the commission did exactly that. The error report has been availed to this court, but of significance is that as they were preparing that error report, a copy of that error report was also availed to the agents of all the parties. This is important in the architecture of our elections. It is important because, as opposed to asking the court to now go through scrutiny, it will be a question of saying, wait a minute, in the error report, there's a difference between the results that came from member primary school, which I have either in my carbon copy from my agent, or that was presented by the returning officer, and what we are now seeing in the portal. That is the only way through which somebody could make an allegation that would stand the test of time. If you have that, then certainly, if you apply yourself to understand the architecture of our electoral platform, then there is really no need to go into scrutiny, because that report is scrutiny by itself. In fact, it was a forensic audit. They had their watermark readers, they had their UV light readers, and these are things that are all contained in the affidavits of these three individuals that I've spoken about. When you take time, you look at that, and it is then our submission that to the extent that there is an allegation that there were interferences or that there were differences between the Form 34As in the portal and the Form 34As physically presented by those returning officers, there was none, and this is verifiable. Indeed, none has been presented before you. The last issue I'm to deal with is whether there was a difference between Form 34As uploaded on the Iebc. Sorry, I think I've gotten into that point as well. And so, there was a question that was raised about Form 34C and the concern about the multiple entries. Submission was made by council that the Form 34C is supposed to be generated once. Again, that sort of submission would only come from a false, if not limited, understanding of the process. I say that because as the verification and retallying of the Form 34As were going on at the National Tallying Center, whenever they completed the verification and retallying of a constituency, they would then upload it onto the Form 34C after the completion of the verification. That then meant that that process had to be an incremental process. That is why when somebody says that there is a gentleman called so-and-so who accessed the server or the rear end of the result transmission network 1,000 times, it simply speaks to the fact that, according to the jurisprudence in Maina Kiai, results from the polling station, which is the original Form 34A. Now, if we look at the number of the polling stations, it speaks to about 46,000 and a few hundreds. It then meant that a corresponding number of entries had to be made on that Form 34C. And that, because I'd said it is supposed to be done incrementally, I would want to refer for clarity again to the affidavit of Commissioner Justice Nyang'aya. At paragraph 51 of the affidavit of Commissioner Justice Nyang'aya, he says, or he acknowledges, that indeed it would be inaccurate, impractical to expect the 7 commissioners to be the ones to do all these specific assignments that the commission is supposed to be doing. Similarly, and by parity of thought, when the law says that the commission shall, for purposes of this, generate that Form 34C, the law does not contemplate that the chairperson of a commission will sit with a laptop and make 46,000 plus entries by himself. This is what my learned senior counsel Kamau Karori was speaking to. This is what is contemplated under Section 11 and 11A of the Iebc Act. And so, if we then tie this to the submission that he had earlier on made, that if we read under Article 138(3)(c), the Independent Electoral Commission to mean the entire institution, then we would not run into the problems that we are running into. Because as we saw, and as will be demonstrated in, by our subsequent speakers, that exactly is what happened. The entire bureaucracy or the entire institution of Iebc participated in that process. As I conclude, I want to make a submission that when we make these allegations in our election petitions, perhaps we need to also ask ourselves if we have done that which the law contemplates of us. That if the law gives you an opportunity to choose your agent for purposes of verifying or speaking to you in relation to the processes in the election, if you fail to present an agent, would it be appropriate to then come and burden the subsequent processes through applications such as what we're seeing for scrutiny? Because the law contemplates that that agent should be able to point you to the fact there's a problem in a particular primary school. Go there. Don't ask for the entire of a constituency. Don't ask for the entire of a county. And I think that has been the jurisprudence that has been developed. It then follows that we must sanctify the place of agents in our elections. And because agents are like our spouses, you choose your own. You choose the one you trust. If you get, nobody imposes an agent on you. If you choose one you don't trust, then really you can't blame anyone. If you choose one who does not understand why you assigned them that responsibility, again, you cannot possibly blame anyone. So, as I seek to take my seat, we ask, my ladies and my lords, that in the usual strong manner in which you've spoken in relation to these issues, and following the very lengthy submissions that we had yesterday, we also rely on you to help us clean this electoral system, so that as the commission does its part, on the other hand, the public and every other person must also do their part. I am most obliged, and thank you for according me this opportunity.
Having just come in, good morning, your ladyships and my lords. I'll take as short as possible. In order not to repeat, I will be very brief. Arising from the questions asked by the court, I'd just like to put it on record that and of course, in particular, the very rapid submissions of my learned colleague, Mr. Mahat. Sometimes you miss exactly what he's saying, but I picked out that he did not at all mention how the system for the KIMS kit was converted to the provision of PDF. The tender document, and we have provided evidence of it, did provide that the KIMS kit would transmit a compressed color photograph image using a compression technique that is in compliance with JPEG. That requirement was never changed unless it was changed quietly, fraudulently, and with the sole intention of rigging the just concluded presidential election. My learned friend, again, Mr. Mahat, challenged everybody that if there was a program that could convert a PDF document or could edit a PDF document, they would buy it. They would buy it. I suppose he meant the Iebc. I, at that point, did ask whether he's an employee of the Iebc, but I was assured he was not. I would like to state for the record that the software for editing a PDF document is available free of charge and can be downloaded by him or the Iebc. And we would request that millions or public money not be used to do this. But the programs that exist for editing a PDF document include Adobe Acrobat DC, Foxit PDF Editor, PDF Filler by AirSlate, PDF Element, Small PDF, Nitro PDF Productivity, Fine Reader PDF for Windows and Mac, Adobe PDF Pack. And I would also invite the court perhaps to try any one of them out. Staging, I just want to add that staging is admitted, even by IEBC. So does not lie in the mouth of counsel, belatedly briefed to deny that there was such a facility. Mr. Maina Wachira Nyaga, paragraph 2 of his affidavit, sworn and filed on 29th August 2022, confirms there was a middleware in the results transmission system. And this is also confirmed by one of our IT experts, Mr. Benson Wesonga, that there was indeed an attack from the position of man in the middle. At page the evidence we produced of the data analysis by George Njoroge in his affidavit sworn on 28th August 2022 and filed on the same day, pages 68-73 of his report, Mr. Njoroge says that the results from the the results from the polling station was between the 9th and 14th of August tallied 137,000 times 137,847 times. On the 9th of August, 38,353. On the 10th, 35,000 times 557. 4th August, 24,000 times 897. This shows that numbers, the same numbers, were being brought back into the system from 34s, new 34s. Otherwise, and trying to find the magic number that would give the first respondent the win. Finally, I would like to make a few comments on the just concluded exercise, the scrutiny exercise, and state that very shortly that despite the good intentions of the court, the servers were not opened. Unless, of course, there will be another opportunity for us to make a few comments. They will? Or then
stop any conversation about the report at this stage.
Okay.
We will allow you time to deal with the report.
Okay. I want to say that
there were protests, but the commissioners took the firm view that it would be responsible for them to let their infightings be made public for fear of eroding public confidence in IEBC during an election year. And it is for that reason that they chose to handle their differences diplomatically. Madam Chief Justice, these matters are contained in the affidavits. They are further clarified that although they were willing to tolerate corporate governance infractions with equanimity, they were not ready to do that with regards to serious constitutional violations. There is no doubt that they were not involved in the tallying or verification of results at Bomas. The only thing that they would do is that they would be given results sporadically at the absolute discretion of the chairman to read, which they did, sometimes with embarrassing consequences, as were explained by Paul Mwangi in the morning. But they could not stand it any longer, Madam Chief Justice, when they were now being asked to sanction results, and they were not being asked, given information that they needed before they could sanction such results. And they were quite clear that the results would not be delivered unless and until the winner is proved to have 50% plus one of the votes. All they were asking for, Madam Chief Justice, was information that could satisfy them. That stand. Madam Chief Justice and honorable members, at this point, allow me to call Apple Lumboya to come and explain exactly what kind of exchanges ensued earlier on between the 4 commissioners and the chairman. Thank you very much.
Your Ladyship, the Chief Justice, we are not accused of rehearsing a new case. The question that the court asked is that please show us that there were problems that was brewing. That is the question that the Honorable Judge, Justice Lenaola, and the Deputy Chief Justice asked. Yeah, members of the court, if you look at the 5th respondent replying affidavit, Juliana Cherera, Annexure JC2 are memos. These memos are way back from April, when the chairman unilaterally caused the reshuffling and transferring of returning officers. And just to read one of 12th April of 2022, the three commissioners, that's Juliana Cherere, Justice Nyangaya, and Francis Wanderi, says as follows, addressing the chairman: we are specifically addressing your direct role in blocking our participation in corporate decisions making on the area of policy and oversight in the context of staff deployment. In that annexure, there are several memos going back up to April. That is almost 4 or 5 months after the commissioners had joined. Because of lack of time, and the only request I want to make to this court on behalf of those gallant 4 commissioners is that in your decision, you'll find a paragraph to shower accolades on these 4 commissioners for blowing the whistle to the infraction to our Constitution. And that the results that were read by the chairperson of the commission were dead on arrival. And since we have a self-confessed mortician in our midst, we will appropriately request that the funeral rites for those results that were announced be performed appropriately. I call upon my colleague, Issa Mansour, to take over.
Good afternoon, my Lady Chief Justice, the DCJ, and judges of the Supreme Court. I'll very quickly go through the remaining questions asked by the judges. The first one, I think I'll combine them, and I'll just indicate who had asked these questions. The question by Justice Lenaola, whether the violence at Bomas affected the ability to announce the results of the 27 constituencies. The simple answer is no. My Lords, the position taken by the 4 commissioners is that there was opportunity, and as has been confirmed by my colleagues from the Iebc, to deliver those results in the morning. It was not taken, and the failure to announce those results in a respectful view triggered the scuffles and the protests that you witnessed. The next question that had been asked by the Honorable Chief Justice and the Deputy Chief Justice is whether the Commission was dysfunctional, and at what point did the Commission stop functioning as a corporate entity. The simple answer has been explained by my learned seniors, but the correct position is the Commission continued acting as a corporate entity, but it had serious corporate governance issues. And this is confirmed by the fact that they were able to deliver a general election, they were able to train presiding officers, so the Commission continued working as a corporate entity with the Secretariat and the team behind it, but they had serious corporate governance issues that have played out in the proceedings before this court. The third question that has been asked by the Chief Justice is what steps were taken, and this is, you'll find in the replying affidavit of the Vice Chairperson of the Commission, As early as April, as my seniors have said, when these issues about deployment of the election managers and presiding officers was brought to the attention of, came to the attention of the commissioners, the matter was dealt with at plenary. And they wrote to the chairperson objecting and raising those issues and all the other issues, my Lady Chief Justice, that arose in the management of the affairs were dealt at plenary. The only problems you would note in their replying affidavits is that it's only when the chairperson took unilateral decisions in the name of the commission, that's where the problem was. And this is set out in paragraph. Why was the public display of results stopped? When you look at the replying affidavits of these 4 commissioners, all say the same thing. That public display was stopped by the chairperson, and they requested him to ring for today. Was an answer from the chairperson as to why. That silence speaks volumes. The last question was the question that was asked by identification is biometric, and where that fails, it's by the kit. So, my Lord, the IEBC has a constitutional duty to put in mechanisms to empirically identify these kits are configured towards the keep Sunday information, which Mahat was explained today. They must tally with the number of people who turned out to vote. So when you're looking at those, so when they give a percentage of the number of voters who voted, and you look at the tabulation in the final from 34C, those numbers have to merge, and they have to make sense, including the from 32As. That is why the turnout is critical. It gives transparency, and it helps to give credibility to the process. And that's why.
I will be addressing the first, second, and third issue in the list of issues that were framed by the court. My ladies and my lords, I will, in addressing you on those issues, rely on the affidavits of Michael Ouma, dated the 26th of August 2022, and rely on the affidavit of Juan Martin Washira Nyaga, dated the 27th of August 2022, and the affidavit of Hilda Kavonga, sworn on the 27th of July 2022. So coming to the first issue, which is whether the technology deployed by the IEBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results, I will take a few moments to demonstrate how the technology that was deployed in the just concluded elections then met those constitutional imperatives. As a starting point, my ladies and my lords, we may want to ask ourselves, what exactly is this technology that we are talking about? And in answering that question, perhaps a bit of context would be of help. In the period just before the 2007 elections, when we still were dealing with the defunct Electoral Commission of Kenya, the legislative provision then, the equivalent to our Section 44, was worded in very loose, perhaps permissive terms. It was that to the effect that the Electoral Commission shall use technology where applicable or as may be appropriate. After the 2007 elections, we had the Kriegler recommendations, which then, one of which was that we must employ, or we should employ, the use of technology in our elections. When we got to the 2013 general elections, there was a good attempt at using technology, but the various forms of technology that were used were not were in different platforms, so that there was a different platform for purposes of registration, for purposes of identification, and a different platform for purposes of transmission. That did not work very well, perhaps because of the inefficiency attendant to the system then. Came the amendments in 2011 to Section 44, which required
the application which he indicated earlier, My lady, we will of course be
that the
guided.
technology to be employed was one to be integrated, meaning that in that one solution, we had the solution, we had the option for voter registration, which is biometrics. The second was electronic identification of voters and electronic transmission of results. Now, the question that we have before you today is whether, as conceptualized, that solution then meets the constitutional imperatives under Article 86 of integrity, verifiability, security, transparency, and accuracy. I will take a moment to just demonstrate how each of these would have been achieved. But when you retire, though, to consider the decision, I would invite your attention to specifically the affidavit of Michael Lohuma, who sets out in a very granular sense how these imperatives were met. I then would want to talk, that is specifically paragraph 39 to 49 of the affidavit of Michael Ouma. I then would want to talk a bit to the process entailed in those three items. And I'm sure we are most of us are familiar, those of us who have participated in elections are familiar with that process. That once the voting has been done and the polling station has been converted to the evening now for purposes of tallying and counting of results, we start by the counting in a very transparent manner. The presiding officers count each and every ballot, and I'm sure we've witnessed this, showing a vote for Gumbo, a vote for so-and-so, and a vote for so-and-so. Now, at the end of that process, they are then tabulated to give us Form 34A. How then is technology infused in Form 34A? Form 34A has internally identified security features. There are 8 in number. We have watermarks, we have UV potentials, we have microtext, amongst other security features. What is the significance of this? It is so that when somebody looks at the Form 34A, the original, it cannot then be confused for any other form, and that whatever it is that happened at the polling station remains an authentic representation of the will of the people. What then happens is that after that form has been tabulated, it is captured with a KIMS device. One copy is sent to the National Tallying Center. Another collects all the, takes the Form 34A for purposes of the collation to the constituency tallying center. That, again, is to achieve the constitutional imperative of verification. When we get to the constituency tallying center, the returning officer has a back-end access to be able to load their Form 34B and transmit it to the National Tallying Center. Once that is done, they will then go with their Form 34A, together with their Bs, to the National Tallying Center for purposes of the verification and tallying at the National Tallying Center. Again, it is important to note that by the time the returning officer gets to the National Tallying Center, we have the image that is already in the portal. When they get there with their original form, an opportunity is then presented again for verification, for confirmation of accuracy, and more importantly, that in this election, because of the decision that was rendered by this court in the Raila Odinga decision in 2017, the commission, in reconceptualizing or reconfiguring its electoral architecture, gave a public portal for people to be able to also follow, thereby meeting the constitutional imperative of transparency. It then meant that if I'd gotten my results from my village, my primary school where I vote, I would be able to follow those results all the way to Nairobi and take account and follow if at all there is anything that would have happened or changed, then I must be the first person to be able to raise that concern. It should also not be lost that in that polling station, we have our agents, we have our observers. Again, to add to the fact of verifiability. So that then is the architecture of what our election pathway looks like. That said, it then must follow that at the polling station, if I am a candidate, I certainly must have interest in the outcome in that particular polling station. Because a copy of the results from the polling station would be given to me, I then should be able to communicate with my team, perhaps my national agent for a particular candidate, a particular party, to be able to demonstrate that what we got in member primary school and what has been transmitted to the National Tallying Center is one and the same. And that in the event that there's a discrepancy...
And this is very serious. Either we practice law the way we understand the law, or anybody can confront the court with any document at any time. I understood Mrs. Soweto to be giving an explanation in response to a question by the court. And similarly, Mr. Mohammed was responding to question by the court. And therefore, he had some latitude. But now we are entering a different universe where he is now going to produce evidence. He is saying how the picture was taken. There is no certificate, and this is electronic evidence accompanied by an original. I think it is very, very dangerous territory. And unless some clarity is given on this matter, it is going to be very difficult to operate from now.
My lords, what we are trying to do is to show you documents in our own affidavits in response to documents produced from the bar. Ms. Soweto never produced the document she showed you in any of her affidavits. When we now invite you to look at the original and to make the argument that my learned friend is about to make, that there is a deliberate misrepresentation of what the original document looked like. So we are treated to this attempt to block that fact from the court. This is not a legitimate objection. This is an attempt to interfere with legitimate evidence that is on record.
Okay. Let's give it directions, because we'll be here until tomorrow and we don't have this time. Senior Counsel.
Just one point. And I'm normally very quiet, and I continue to be very quiet. But the good professor has misunderstood Ms. Soweto completely. It is not this document which is in question. It's the way the interference is being done, how this document is changed to another document twice or three times. I think the good professor will be doing a good service to the court. And if he is good coming to court with clean hands, he should first of all say, Mrs. Soweto, what Mrs. Soweto showed us today is not in their portal. That is the starting point.
Isn't that exactly what
that is the starting point.
Bear with us, Senior Counsel. We've come thus far with a lot of discipline and dignity and respect to the court. The reason why we are here, and you saw us take a lot of time to reflect on the application that was made by, I think he started with Mr. Katwa Keegan, Mr. Kirago, and Mr. Ngatia. We resisted until we established from the pleadings that we have that these are new forms, and indeed they are entitled to respond to them. So please, if you can just respond without taking us into anything else, just respond to those new forms, because they were not part of the ones that we have before us. We established that.
Thank you so much, Madam Chief Justice and members of the court. The difficulty we were facing in thinking about this, an allegation has been made as relates to this form, and there's an overlay of someone called Mr. Jose Camargo. What we were trying to show the court that this is an overlay document, and we wanted to actually show the court where this document from Jose Camargo has come from. The document relating to Jose Camargo has come from the QR register, which is distributed to every polling station. And that document is even in the possession of this court. If you look at the scrutiny report, the QR documents are there. So what happened? Apio took an original Form 34A, he had the QR register, and he took a picture of it. What is the evidence that is being given in this court? That someone called Jose Camargo is interfering with this. And the point we want to make to this court is that if you look at the scrutiny report and if you look at the QR register, which is in those boxes, you will actually find the name of Jose Camargo on the register that has been printed. We've also produced the original Form 34A. We've come with the receipt. And we're being told that you cannot produce your original 34A, that Jose Camargo was interfering. And in fact, if you look at the numbers on the original 34A, it's the same as what the picture of the overlay was taken. So to the question that someone called Jose Camargo was interfering with the portal, it's actually not true. It's incorrect. And the attempt to prevent that evidence to the court should actually guide the court that actually that is not true. Why will anyone try to interfere with a portal transmitting, and the result he has is the same as what is in the A and what is in the portal? So to that question, we submit that that is not true, and that is an overlay that someone who has taken the picture. We will give the court the Form 34A to compare with the original 34A with the certified copy that the court has. And in fact, we direct the court to the scrutiny documents. That register of opening and closing the KIM is there, and the name of Jose Camargo for purposes of audit trail is printed in there. Smartmatic Jose Camargo is printed there. So what has happened? Someone, Apio, took a picture on that one. The next point I want to make is the issue of the KIMs. We've been told there are two KIMs kit which had the same serial number. And we understood our role to this court to give all the information to the court to make a decision. We admit that those KIMs have the same serial number. It was an error that originated at the time of the serialization. But we want to tell the court that those KIMs have different IMEI. They have different IP addresses. They have different polling stations. They have different identifiers. And we acknowledge that that is an error that originated relating to those two KIMs. But there are other identifiers that can identify those KIMs are from our system. And we want to give that information to the court for purposes. Those KIMs are on the way to this court. We will give to the registrar of the court for the court to analyze and to look at it. And if you look at those KIMs, they transmitted the forms as required in the portal, and the A's also are coming, the original A's, we will also give for those three forms. And our role is to give. The issue of transmission has come up. I just want to say this. There were three sets of transmissions at Bomas. One on the forms that has been downloaded, that was running properly. The second one related to the constituencies, that was continuing. The one which had stopped was the one on the tally. And the reason it stopped was, for 3 days, we had only verified 50 arrows. The process became clogged. For you to be able to transmit to the announcement, verification had to happen, then announcement happens. That means that those arrows have to be stopped, because verification cannot happen as announcement is happening. We will be running numbers that have not been announced yet. So because of that, and because of the audit that most of the agents were recommending, we had to stop that process to give verification a chance. There was nothing malicious about that. Those few remarks, Your Ladyship, I stand guided. Thank you.
Mr. Mahat, maybe we can have a look at the original
My lady, if the
34 that you are showing.
Sorry, my lady, Chief Justice, if the form can be handed over to the court. Excuse me, a moment. Thank you. Thank you. My lady, my learned friend, Senior Counsel Mulgore, has a comment after the court has seen the...
As you continue to look, we'd just like to make an observation. In fact, we are happy that the court receives the document, particularly the Form 34A, and everyone has been quoting Shakespeare and all the rest. I'll just quote some Swahili. Siku ya nyani kufa, miti yote huteleza. If you notice on the 34A, the UDA agent, the second agent, signed the form on the 7th of August, 2022, before the election. Before the election. I repeat, before the election. The other one as well, perhaps might have signed it on the 7th, but it's not clear. So that's all we wish to say.
While at it, Counsel, just before you go back, and when did the other agent sign?
It looks like 7th, it looks like 9th. Only the Iebc and Mr. Chebukati can tell us. It is there.
Yeah, before they explain, they would have to have something to explain.
We have let it go in.
This form, from the naked eye, of course, appears to have been signed by both agents on the same date. And the same date is 07.
Oh, 07 of 08.
07 of 08.
Yes, indeed.
See, well, I thought the point you were making was that the second one signed before the election. As though the first one, if I could just finish,
okay.
As though the first one had signed on a different date.
No, our point is, and has always been, these forms may have been manufactured elsewhere, before, well after voting, and they all arise one day and they are counted. It is the mess that is IBC, and it is the mess that is the 2022 presidential election that we have been emphasizing. Thank you.
You still want to talk?
Madam Chief Justice, my client is the one who is likely to suffer most in case these sensational matters are not dealt with effectively. Starting with the date, that is more of drama than reality, is seeing a speck in the other person's eye when the log is in the other person's eye. One of the things I think I ought to place on record is this. The forms that are now in issue have not been pleaded, were not tendered, and since they were not pleaded and they were not tendered, we should not be accused of not having responded to them. Point number two, both agents have made a legitimate or have made an innocent mistake about the date. And I don't see where the laughter is emanating from. Point number three, the form itself shows a contrary position to that which was sensationally displayed before this court. The sensational reporting that was made was intended to convey a picture which is to the opposite of what the form now before the court conveys. And that reminds me of that very unfortunate day in 2017 at 9 p.m. that again sensational claims were made about forms 34B from Mombasa, in particular Shangamwe, made also to this court, and which led to a nullification of a presidential contest. Madam CJ, there is also one more thing that concerns my client, because again, it has very prejudicial effect. It is what is definition of the commission. I will spend 1 or 2 minutes defining the various ways commission is defined in the law. Commission is first and foremost defined in Article 88. Commission is also defined.
Sorry, if we open the matter now to other things, we will not see an end to this. You are responding to the 2 forms which were introduced.
As new evidence.
Yes, please don't go to other things that you are not supposed to, because we will not see an end to this.
I still have my time.
With respect, even if you have your time.
For the governor,
even if you have your time.
Thank you.
Just deal with the 2 forms.
So then, coming back to the forms, my request is this. Please delete from the... yes, the other thing is that all the form now before you has security features. The one that was displayed does not have. The one that you have does not have the name of Jose Camargo. The one that was displayed before the court has that name of Jose Camargo. The original one you now have does not have that name. And all those things were meant to deceive. They were meant to mislead.
We should never have to ask that we remain the way we started. We should never have to ask that.
Particularly from such eminent lawyers. The one that you have does not have any of those things that were displayed. My client therefore becomes quite concerned whether this case is to be adjudicated in the realm of falsehoods or within the parameters of factual contestations. That is a real concern. The minute we allow matters which are clearly false to infiltrate into the record of this court, we are likely to get into a very, very unfair decision. Let this case be decided on factual points and on factual contestations. We say the same about the second form, that the original has not been provided. But as regards the second one, allow me to say this. Before this contest started, Iebc did avail to this honorable court all the forms 34As. All of them were deposited because we did see that correspondence. Consequently, as regards the second form, I would request this honorable court to find time to look for it, the certified copy, and in case once again it does not have this JOS, whatever name it is, please come to this conclusion that a deliberate effort was made by counsel to mislead this court so as to arrive at a decision which would be most injurious to the first and second respondents. I'm very grateful for the 5 minutes, and I rest.
Thank you very much. With your permission, we would like to go to another segment of these proceedings, the last of them, where we'll be considering the report from the scrutiny or the discovery that was undertaken by the court, and I will ask the Honorable Lady Justice Joaquin Dongo to take us through that session.
Thank you very much, Madam President Judge. Before I come to the issue of the exercise before us, I just wanted to assure Senior Counsel Paul Mwite that when the 14 days start running, and we are guided by Article 259, when we do work Saturdays and Sundays. So as soon as the time is triggered, in fact, the judges are working all the time. You're the ones who get to go home and rest. When you rest, we go and we continue to work. Thank you very much. So just before we proceed with the next session, it was just a summary of the order that we gave to parties and the rationale for those orders. We received 3 applications from 3 parties, from the Youth Advocacy Africa. We received an application from Khelef Khalifa, and we also received an application by Raila Odinga and Martha Karua, in which we were asked, the press was sought to undertake scrutiny and access to certain information. After we looked at the applications and the prayers, we then looked at the pleadings and the affidavits to ensure that the prayers matched with the pleadings and the affidavits that have been filed by the petitioners. As you will recall, the court then determined the issues which we will determine, and that also helped us set out the orders for scrutiny, so that our orders were set out based on the pleadings, the affidavits, the issues for determination. But further to that, we also did say in the body of our order that we would not encourage a fishing expedition, and that the request needed to be specific, and that given the 14-day timeline, the court would only allow reasonable, practical, and helpful orders. We also acknowledged that under Section 12 of the Supreme Court Act, the Iebc has already submitted all the Form 34As, and therefore they could be accessed in the court. We also stated that some other issues, some other things that had been requested for in the prayers are in the public domain, and that parties could then get those. We did note that some of the requests or the prayers were unrealistic. Some of them were general and vague. Some of them involved parties that were not enjoined to be before us. And therefore, we granted orders not based on prayers, but based on what we assessed that the court needed to look at in terms of all those criteria that I have set out. And therefore, the exercise that was conducted under the hand of the registrar followed strictly the orders which were given under the hand of this court using that criteria. I think that is a fair summary. Madam Judge President, I will stop there.
Thank you. I think an exercise was carried out, a very rigorous exercise led by our registrar. Indeed, these are people who had not slept for 24 hours working to carry out this exercise of ensuring that there is compliance with the orders of this court. Our staff actually spent a night here. They had to shower somewhere here and continue working yesterday morning. So the report has been shared with council online, and because the parties who are involved in the requests for the discovery is the main petitioner, the Youth for Advocacy, and the petitioner Karif, we have decided to allocate each one of you 15 minutes to submit on any issues you like us to take note of in the report. That is the main petitioner, 15 minutes. Youth advocacy for Africa, 15 minutes. Karifa, 15 minutes. Then we will have Iebc, 15 minutes. And because the first respondent is also affected by what is being discussed in the report, we also agreed to give them 15 minutes. Yes, you have the floor.
Thank you very much, Your Ladyships and my Lord. I'll be as quick as possible, and I would like to indicate that I will share the time with my colleague Jackson Awele, who will deal with what happened at Forodha, while I will deal with everything that happened at Iebc Anniversary Towers. The report the court has given runs into 178 pages. But we worked overnight to provide written observations to the court, which we filed this morning, and so all parties are actually aware of whatever it is the first and second respondents, petitioners have observed. Very quickly, Iebc confirmed that the RTS, the results transmission system, runs on 8 servers, of which one is a virtual server.
Counsel?
Yes?
You say you filed something?
Yes, we filed written observations with court, and we have a few copies.
Just wait until we get our copies. Are they in the box?
We filed them
just
before.
give us
Okay.
A moment there. Yes. If you say you have extra copies, you could give us? Yes. So as to save on time.
Yes,
we do not have a copy. If Learned Counsel could be kind enough and serve us a copy.
For the principal respondents, we can give you one of each.
This shows the time we are given to respond.
We served them before 9 o'clock this morning. Electronically. The only thing that there'll be a problem is some of the images will not be very clear, but when you do have time, the images at the end.
Just hold on, Counsel.
Okay.
Yes. You could start.
Yes, Jackson, you could also perhaps upload it so that those who don't have a copy can see where we're reading. I'll go to the first observation on page 2, summarize the first paragraph. Iebc confirmed that the results transmission system runs on 8 servers, of which 1 is a virtual server, and the 7 are Docker containers, which is a server within a server. The Iebc denied agents access to the Docker servers. We were therefore unable to proceed further with that exercise. Paragraph 2, the...
Counsel again.
Yes.
The copies you've given us are not filed.
They're not filed, the electronic ones are filed. I anticipated having to provide 1 or 2 people with copies, but the electronic ones are filed, very clear. We have a receipt.
Yeah. It's all right.
Okay.
Counsel, I think We had already given directions that we expect oral submissions.
I am making oral submissions.
Yes, so I'm just saying, let us not worry too much about written reports, who has served who. You're letting the court know what you think of the exercise so that we can take those submissions into consideration. And that should apply to all the other parties.
I stand guided. Thank you very much. I go to paragraph, or I'll just make it an oral submission. The virtual image availed for scrutiny was created on the 31st of August 2022. We therefore state that this cannot be from the same server that ran the just concluded general election. And the image of the server was not provided. The further major observation we make, the KIMS kit was not availed for scrutiny to establish the availability of the embedded scanner application that would verify the image format. So the Iebc declined to avail the system documentation. I go on. There was very disturbing evidence of log deletions from the Iebc server that was availed, in part, partially availed. These deletions occurred on the 6th of August 2022, which is 2 days before the contested election. We observe that, surprisingly, the registrar's report at page 21, issue number 5, indicates that there were no deletions. We think this is a mistake. It should be looked into. The effect of the deletions, we can upload that. It's on the screen now, that we were able to get from Iebc, indicates that, and this is image marked 15, that at the material time, foreigners, including Ogudino, Vito, J. Carmago, Josio, were operating the system. Those are 1, 2, 3, 4, 5 foreign individuals. If a forensic image of the server is availed, details of what was deleted would certainly be established. The other major observation, Iebc refused to provide a security walkthrough to highlight key security controls to determine whether Form 34A could be tampered with during transmission and at what point. So we hit a dead end, contrary to what their counsel repeatedly says. They are transparent, it's available. They're even giving the court, donating to the court KIMS kits to look through. Finally, or, well, not finally, Iebc refused to grant access to the forensically imaged servers. Instead, the server administrator projected the vSphere, which is the Virtual Server Application Management System, on the whiteboard to demonstrate the access to the servers. The vSphere indicates that the virtual RTS server was created and modified on the 31st of August at 2022. In effect, no information from a server was provided to show what happened during the 2022 general election. Number 11, a couple of manuals were provided, or bundles of documents. We'd like to point out that of interest to the court would be that at page 77 of one of the manuals titled Information and Communication Technology ICT Policy, at page 77 and 78 is a list of 77, a list of 41 individuals, starting with Dixon Kwanusu, and second one Abdi Dahir Abdi Malim, who are described at the top of the page as national returning officers, an office unknown to the law or the Constitution. I would request that the court takes note of that in particular. And paragraph 14, on the 1st of September 2022, the deadlock over the servers finally came to a head when Iebc wrote to the Registrar of the Supreme Court enclosing a letter dated 31st August 2022 from Smartmatic International BV, the same company that Carmago comes from, in which the letter states, amongst other reasons, the image of the NTC servers containing software owned and copyrighted by Smartmatic and thus IP protected. providing full access would infringe our intellectual property rights. That brought to the end that matter. Smartmatic, Camargo, whoever they are, wherever they are from, have indicated that they will block and refuse access to the servers completely. I then move to the images. Certain images were shared by Iebc. I'm not certain that they were aware of what they were serving. There was always a staff that seemed quite unqualified in whatever they were doing. They couldn't operate the systems or pretended they couldn't, but they did share image number 6. The first image I showed was the image of deletions, but the one I would like to focus on in this very limited time is image number 6, which is several, about 1, 2, 3, 4, 5 pages of logs. The logs are from the RTS server, results transmission system, on various days leading up to and after the election date of the 9th. In particular, 15th July 2022 to the 16th of August 2022. And I must apologize to bring the bad news not only to this court, but to the entire Republic, that those logs contain active participation of foreigners on the results transmission systems of Iebc from the 15th to the 16th of August, 15th of July to the 16th of August 2022. Their names are Vito, Josio, that is the names identified in these logs, Josio, Ogudino, Sisiva, Provisio, and Jacamargo. The copies I provided to the court are much clearer, and you can see the names, you can see the times, and of interest, and I will only highlight certain entries, only the longest entries. I will start by saying those 1, 2, 3, 4, 5, 6 individuals, foreigners, in the Immigration Act they are also referred to as aliens, accessed this server 180 times or thereabouts. The longest being Camargo on the 8th of August 2022, Josio, let me deal with the time. Josio on the 9th of August 2022, which is the election day, for 1 hour 32 minutes. Ogudino on the 11th of August 2022, 2 hours 54 minutes. Ogudino again on the 11th of August, 3 hours 16 minutes. Ogudino on the 14th of August 2022 for 2 hours. Ogudino on the 4th of August again, 1 hour 57 minutes. And then the 16th of August, Ogudino, 1 hour 1 minute. I close by saying, what a mess, what a mess. My learned friend Mr. Ngatia struggled so hard to get Mr. Camargo out of the mess of taking control of our elections. In the case of the 34A we've just been talking about, but we have caught Mr. Camargo and all his friends in our election process before, after, and where are they? Only God knows, and only the servers will show us. History is repeating itself. 2017, Mr. Chepkati refused to provide access to the servers. He's doing it again. And of course, please, I ask the court to take note of everything we have provided as far as the DCI has provided to us, we have provided to the court. These are individuals whose identities are not even known. They travel on, or they provide expired passports when interrogated by the police, and all the rest of it. I would not repeat any more of that. On the 8th of, yes, I'm happy to be pointed out, the logs will also show that on the 8th of August 2022, Camargo accessed the portal while in Venezuela. So our elections were conducted from Venezuela. The Venezuelans decided who won. Mr. Chepkati was just a mouthpiece. Thank you.
My Lady the Chief Justice, my Lady the Deputy Chief Justice, my lords, my ladies, in the remaining few minutes, permit me to take you through our report from the scrutiny exercise carried out at Forodha. And my lord, I'd like to very quickly just highlight sequentially in the order in which the ruling was made.
Did we get your name for record purposes?
My apologies once again. Jackson Awele is my name, my lady. My lady, in the order in which the ruling was given, order number 5 granted the applicants inspection, scrutiny, and recount in respect of 45 polling stations. There were about 16 polling centers, and within them we had 45 polling stations. Now, in conducting the exercise, our focus was on qualitative aspects of
having just come in, good morning, your ladyships and my lords. I'll take as short as possible. In order not to repeat, I will be very brief. Arising from the questions asked by the court, I'd just like to put it on record and of course, in particular, the very rapid submissions of my learned colleague, Mr. Mahat. Sometimes you miss exactly what he's saying, but I picked out that he did not at all mention how the system for the KIMS kit was converted to the provision of PDF. The tender document, and we have provided evidence of it, did provide that the KIMS kit would transmit a compressed color photograph image using a compression technique that is in compliance with JPEG. That requirement was never changed unless it was changed quietly, fraudulently, and with the sole intention of rigging the just concluded presidential election. My learned friend, again, Mr. Mahat, challenged everybody that if there was a program that could convert a PDF document or could edit a PDF document, they would buy it. They would buy it. I suppose he meant the Iebc. I, at that point, did ask whether he's an employee of the Iebc, but I was assured he was not. I would like to state for the record that the software for editing a PDF document is available free of charge and can be downloaded by him or the Iebc. And we would request that millions or public money not be used to do this. But the programs that exist for editing a PDF document include Adobe Acrobat DC, Foxit PDF Editor, PDF Filler by AirSlate, PDF Element, Small PDF, Nitro PDF Productivity, Fine Reader PDF for Windows and Mac, Adobe PDF Pack. And I would also invite the court perhaps to try any one of them out. Staging, I just want to add that staging is admitted even by Iebc. So it's not, does not lie in the mouth of counsel belatedly briefed to deny that there was such a facility. Mr. Maina Wachira Nyaga, paragraph 2 of his affidavit, sworn and filed on 29th August 2022, confirms there was a middleware in the results transmission system. And this is also confirmed by one of our IT experts, Mr. Benson Wesonga, that there was indeed an attack from the position of man in the middle. At page the evidence we produced of the data analysis by George Njoroge in his affidavit sworn on 28th August 2022 and filed on the same day, pages 68-73 of his report, Mr. Njoroge says that the results from the results from the polling station was between the 9th and 14th of August tallied 137,000 times 137,847 times. On the 9th,
and we have isolated some few issues that will urge the court to consider in perusing the report. And one of the notable issues, and I concur with what my learned friend Mr. Awele has observed, is that we came across in a process that I personally participated in what learned Judge Justice Njoki has observed, that it is a process that took more than 24 hours. We came across ballot boxes that did not have original or carbon copies of Form 34As. Your leadership, the effect of that is that the authenticity of the forms appearing in the public portal is then called to question. There are ballot boxes, for instance, I'll give the Mikindani Primary School, polling station number 8 of 9, the report is appearing at page 81, where it is clearly observed that it did not have the Form 34A. We also have another polling station, that is Chepkulung Primary School, 3 of 3, that did not have the Form 34A in the box. So that then the question arises, where is the source, or what is the authenticity of the Form 34A that is displayed in the portal? Because there is nothing to compare with as required by the regulation. Another notable issue that we came across, your leadership, is that there were ballot boxes that did not have seals matching what is recorded in the polling station diary. My lady, what happens is that at the close of polling, one is required to record the seals that are then affixed on the ballot boxes when they are closed, so that the record of the ballot seals as appearing in the polling station diary, when they don't match what is actually presented to the court at the point of scrutiny, that raises eyebrows. Because it happened in one primary school, you note your leadership from the report, at paragraph, page 53, Majengo Primary School, it's observed that in the report that all the serial numbers had been altered. The effect of this, your leadership, is that we cannot then be sure at what point is the ballot box opened, so that those seals that were affixed at the close of the polling were changed. Alteration of seals is a serious breach of the regulations that govern elections. Your leadership, another observation we made on the broken seals is with respect to Keheo Primary School in a constituency called Ojorok in Nyandarua County. What the report by the registrar of this Supreme Court notes is that the aperture, this is where the ballot paper is slotted in, putting in the box, had a seal that had been replaced. The seal that was noted at the close of polling and the seal number on the aperture at the point of scrutiny had been altered. This is noted, your lordship, my lady, at page 146 of that report that is before the court. The third issue that we also noted is as regards Book 2 of 2. My lady, the Chief Justice and distinguished judges, Book 2 of 2 needs to be put in context. That the IEBC printed Book 1 and Book 2 of Form 34As. When that was discovered, the IBC indicated that Book 2 of 2 will not be used for purposes of reporting presidential elections. But then the assurance that the IEBC gave was that that Book 2 of 2 will be deposited in the ballot boxes and it will not be utilized. Unfortunately, at the point of scrutiny, there were 27 polling stations from the 45, or rather 47 that were to be scrutinized that did not have Book 2 of 2. The question then that begs our minds is, where did the Book 2s of 2 go? Were they used to report results, presidential elections, or where did they vanish to? Because the factual position is that those Book 2 of 2s were missing in at least 27 of the polling stations that went through scrutiny in the process that we undertook. My lady, another issue, and the honorable judges, that we came across is that there were missing counterfoils from the ballot boxes. The requirement under the regulations is that when a ballot is slit from the main booklet, then at least a counterfoil will remain. The purpose of scrutiny will then serve some purpose if you compare the counterfoils against the number of votes that were cast, including the rejected votes. But, my lady, the Chief Justice and judges of the Supreme Court, without the counterfoil being present that you can compare with, then a question then arises as to whether those who are actually the ballots appearing in the ballot boxes were torn from the booklet, because there's nothing to compare with. Counterfoils were missing, my lady, and honorable judges, from Keheo Primary School. This is noted at page 146 of the report. From Keheo Primary School, polling station number 2 of 2. My lady, there were myriad of issues that we came across. In addition to that, with the scrutiny, envelopes, electoral material, these include the ballots that have been cast, the counterfoils that have been used, the register in the polling station, all those electoral materials that the regulations require that they should be deposited in the ballot box in tamper-proof envelopes. But unfortunately, what we came across was that there were very many polling stations from the ones that we undertook scrutiny where all the contents, the electoral material, were not placed in tamper-proof envelopes. And just to give an example of a few, we had Mvita Primary School in Mombasa, that this is noted at page 34 of the report. Polling station, also Mvita Primary School polling station 7 of 7, there were 7 polling stations. That happened also in Mikindani Primary School, polling station number 7 of 9. This is noted at page 80 of the report. We have Chepkutung Primary School, polling station number 1 of 3. We have Kapsusel Primary School, polling station 1 of 3. That you find in the ballot box, the materials are there, but they are not placed in tamper-proof envelopes as required by the law. Your Leadership, we look at those anomalies in line with the provisions of the Elections General Regulations of 2017, and specifically regulation number 81, that require this electoral material to be placed in tamper-proof envelopes and then sealed in a ballot box. When that happens, it is a clear breach of the regulations as required. And then these anomalies, again, it is my humble submissions that I also speak to the requirements on the Article 86D of the Constitution. And my lady, this is clear because it requires electoral system to be accountable, and even requires the IEBC to preserve electoral material in a safe manner. When this has not been done, Your Leadership and honorable judges of the Supreme Court, we submit that that is a clear breach of the Constitution, and no accountability can then arise in the event where such issues have arisen. My lady, having spent my minutes on the issue of scrutiny at Forodha, I'll now hand over the floor to my learned friend Joaquim Bosche to comment on the scrutiny of the technology process. Thank you very much and appreciate. Thank you.
My Lady, the Chief Justice, Honorable Judges of the Supreme Court, I noticed that the time was still running as I was walking here. I hope I'll recover my seconds. As my learned brother has indicated, I'll be going through briefly what happened at Anniversary Towers. Just to add that, my lady, we have already seen the gaps from what my brother, Mr. Njomo, has said. The breaches, the illegalities, and the gaps that were there in the collection, the tallying of the numbers. My lady, what we have been told by the first and second respondents, as you will see it happening even as we went to Anniversary Towers, is the attitude of get over it, it's over. Because, my lady, and as has been ably submitted by my learned senior Mr. Mulgore, when he was talking about what happened at Anniversary Towers, we were denied access to the server. Our agents were denied access to the server. My lady, and honorable members of the court, when you retire, you will see at page 8 of the report, item number 4, that they said the best they could do was to give us a clone image of the server. When we said, let's proceed, or when our agent said, let's proceed, it became clear that to generate a forensic image, there was the requirement for the development of what is called a forensic image hash. My ladies, honorable members of the court, it was then asked for the IEBC because they wanted to give us this clone to generate the hash. What did they say? They said, oh no, the judiciary should generate the hash. Yet, it is the system that they are calling upon us and Kenyans to believe they were in control of. They have no idea how to generate those things, and if they do, they want to take zero responsibility for that job. And that is why, contrary to the requirements of the Constitution, the IEBC abrogated their duty to conduct the IT component of the election and gave it entirely to Smartmatic. And that is why Smartmatic wrote a letter further to the directions of this court, that letter was served upon our firm yesterday. And the letter is dated 31st August. On the right, and this letter should be before this court because it is addressed to the registrar. So I expect honorable members of this court, that it's before you. Clearly, it shows it is from Amsterdam. And it says that they will not give us access to the servers because it infringes on their intellectual property. What Mr. Macharia called today, the question of what happens to our data? We cannot even verify the election, contrary to the requirements of the Constitution that it should be verifiable. When the Honorable Court gives orders for scrutiny, Smartmatic says they cannot give us that access. We have set it out. It's set out in the report that has been placed before this court, and the letter is there to confirm. What they then go ahead and do is to amend the orders of this court. And my ladies will see when you read that letter that they say that instead they would like to recommend that the IEBC makes available, and they say the documents that they want IEBC to give us, including some system logs, which, as Mr. Mulgore has indicated, not all those system logs were provided anyway. And the ones that were provided, we saw who had access. Our agents did indicate that when we asked, because this becomes very important on the question of access, and that's why the logs become important as well, when we asked, as the court had directed in its ruling, order number 1, that we get a password policy, they said no, it will infringe on the security. And that becomes extremely important in terms of knowing who had access to those servers, in terms of confirming the the code or the policy on change of passwords. They refused to give that information. Again, IEBC refused to give us information with respect to the RTS, Results Transformation Systems. Yet they want us to come here and believe what they're telling us with regards to the contents of the portal. Yet in their own Gazette notices, as you will find, there were some points where there was human intervention, and that is why they are unable to explain to this court, which we asked them to do and they were unable to do, to explain how the JPEG photos, my ladies, 2 more minutes? Thank you. They are unable to explain how an image is taken but ends up on the server as a PDF. In their own Gazette notice of 3rd August, which is part of our evidence, the petitioner in 002, they said that in some certain areas, returning officers will be allowed to take photos using their phones and transmit the same to the tallying center. So how then is it that all the photos on the portal are in PDF, and yet they refused, they declined and dishonored this court's order to give us information on the results transmission system? My ladies, my lords, will find when you look at the report that has been submitted, page 11, the judiciary report, that they refused to comply with orders number 1, they refused to comply with orders number 4, they partly complied with order number 3 and number 4. Honorable members of this court, the ICT scrutiny was anchored on those 4 orders. They therefore failed to comply. They refused to open the server. Smartmatic wrote, and to the best of what they could tell us, in addition to amending the judgment, they also say at the very end that even citizens all over the world had full access of these tally reports and were able to add the results, telling Kenyans we have no additional claim of that information. We can tally like everybody else. It is our humble submission that IEBC abrogated their duty. IEBC was not in charge in terms of the technical component, and that is why my brother Willis said they played picky, ponky eventually to determine who won the election. Kenyan electoral processes run outside Kenya. We humbly submit that there was non-compliance. We humbly submit IEBC failed the test. Kindly allow our petition.
I'll start by saying before I start, we were served with a letter just for housekeeping purposes. We were served a letter that my learned friend has referred to from Smartmatic. It was addressed to the registrar of this court. So for EQMs, we will wish to also make reference to that letter as we submit. First thing I must say this. IEBC, in the report by the registrar, I'll start from page 17. You know, the registrar says, forensically captured, compliance task, forensically captured image of the server holding form 34C, not provided. We move quickly to page 21. Virtual server image. All agents were interested in knowing the virtual server creation date. It was established that both the creation and modified date for the image was 31st August 2022, though the technical team at IEBC could not locate the correct data store for the image. Very important. Page 22. The agent requested IEBC to provide certified copies of penetration tests conducted before and during the election. IEBC director ICT director and IEBC advocate provide a certified penetration test conducted before the election. IEBC advocate informed the applicants that IEBC did not carry out penetration tests during the election period, citing penetration tests are not conducted during the election. That is very important, and I asked the court to find out why it's important to conduct penetration tests. At page 24, it was noted that the containers running in the virtual machine are actual computers. IEBC declined to share further details on the containers. Ask your expert why they refused, and they'll tell you. At page 25, what was the IEBC password policy on the server? The response, captured by the registrar. IEBC could not display for security reasons. 31, the agent wanted to know why the user says logs in from server 192.168.95.64. There was no proper explanation for this issue. The agent requested to know if the antivirus or anti-malware was installed. IEBC did not respond. What am I trying to say? Just even from the basic information that was provided to the agents for the scrutiny, IEBC successfully exposed how vulnerable our system was. And for the first year, IT students, I'll give you, they can take down note, what IEBC gave as the memory, the capacity of the server that was provided. Memory was 6.4 GB, clock speed 9.84 GHz, hard disk was 300 GB.